Tapi kesalahan pemula kecenderungannya adalah tangan kiri buru-buru disebut. Nah, sehingga terjadi chicken loop. Nah, jadi buru-buru. Yang ketiga adalah jadinya buru-buru pengen lihat hasil.
SS muka kowe.
Pokoknya lagi.
Jangan pakai login beda.
Oke, benar. Ayo, Mas. Mana baliknya, Dok?
Assalamualaikum warahmatullahi wabarakatuh.
Shalom.
Om Swastiastu.
Namo Buddhaya.
Good morning to all the honorable guest speakers and our moderator.
The Honorable Vice Rector 3 Student and Alumnus Affairs of Universitas Sriwijaya, Profesor Dr. Radianti Umi Partan SPPDKR MKes. The Honorable Profesor Dr. Haji Joni Emirzon SH M.Hum, as Dean of Faculty of Law Universitas Sriwijaya.
The honorable speakers for today's seminar, Professor Tim Lindsay from the University of Melbourne, Dr. Mahbubul Haq from University Sultan Zainal Abidin,
Professor Andre Klip from Maastricht University, Professor Inyoman Nurjaya from Universitas Brawijaya, and Dr. Hamonangan from Universitas Sriwijaya.
And all the honorable lecturers whom attended today's event.
We'll take the advantage of the time to begin today's event by reciting Bismillah.
Bismillahirrahmanirrahim. First of all, let us praise the mighty God for all his blessings so we can gather here in a good condition to participate in today's event, international seminar initiated by the Criminal Law Department of Law, Universitas Sriwijaya, with the theme Exploring Global Trends in Criminal Law, Comparative Perspective on Emerging Issues.
Let us start today's event by singing the national anthem Indonesia Raya and UNSRI's anthem, which will be led by Miss Aurelia Dini Melita. To Miss Aurelia, the time is yours. To all the audience, you may stand up.
Universitas Sriwijaya, lama kemajuan bangsaku, dengan falsafah Pancasila, mengabdi kepada Ibu Pertiwi. Ilmu alat pengabdian untuk menerangi alam semesta dengan semboyan pengabdian ke arah kejayaan abadi. Universitas Sriwijaya, sumber ilmu sepanjang masa, membentuk generasi baru yang penuh semangat untuk mengabdi, melati bunga yang suci, lambang agung keluhuran cipta, dengan rahmat Tuhan yang esa, menuju masyarakat adil makmur.
To all the audience, you may please to have a seat.
The next agenda, welcoming speech by Dean of Faculty of Law, Professor Dr. Haji Joni Emirzon, S.H. M.Hum, to Professor Dr. Joni Emirzon. The time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. Salam, Om Swastiastu, Namo Buddhaya. Ladies and gentlemen, allow me to extend my warm greeting to all speakers. The first, Professor Dr. Ardiati Umi Partan, Vice Chancellor for Student Affairs and Alumni, representing the Rector of Sriwijaya University. Thank you, Prof. And then Professor Mr. Undercliffe, Maastricht University, is that here? Thank you, Prof. And then Professor Dr. Inyoman Nurjaya SMS, Sriwijaya University. Thank you, Prof. Then Dr. M.D. Mahbubul Haq, University Sultan Zainal Abidin, welcome to Palembang. And then Dr. Hamonangan Albriansyah, SMH, Faculty of Law, Sriwijaya University. Thank you for the speaker. Yeah. And also all Vice Deans of Faculty of Law, Dr. Zulhidayat, and then Dr. M. Syaifuddin. And then I respect lecture and academic staff and organizing committee who have worked tirelessly to make this event success. Yeah. Okay, ladies and gentlemen, I'm truly honored to welcome you in this seminar. It advance of celebration of our Faculty of Law 64, yeah, 64 anniversary. And then Faculty of Law, Universitas Sriwijaya, has consistently strived to be at forefront of legal education and research, both national and international. Today is international seminar international. Testament had that commitment as we bring together some of most brilliant minds in criminal law from around the world. The topic today is exploring global trend in criminal law, comparative perspective on emerging issues. And then it's especially timely and relevant today. As the world become more interconnected, so do challenges in criminal justice, transnational crime, yeah, and then human rights issues, also restorative justice and comparative criminal law. Both are pressing topic and demand a global conversation. Through this seminar, we aim to foster such a dialogue by examining how different legal systems respond to these emerging issues and by identifying best practice that can be applied across borders. I am confident that the insight shared by our esteemed speaker today will broaden our understanding of criminal law and inspire innovative solutions to the complex legal challenges we face in today's rapidly evolving global landscape. And then thank you to everyone for your participation. I hope today's discussion will not only enrich our knowledge but also strengthen collaboration between our institutions, furthering the development of legal education and practice for better and more just society. And please, Prof. Haryati to open this seminar. Thanks a lot. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Professor Joni Emirzon, for the welcoming speech.
The next agenda is opening speech by Vice Rector 3, Student and Alumnus Affairs of Universitas Sriwijaya, Profesor Dr. Radianti Umi Partan, SPPDK RMKes. To Profesor Radianti Umi Partan, the time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. It is a great honor for me to be stand here today, representing of the rector of Sriwijaya Universitas Sriwijaya for this significant seminar on exploring global trend in criminal law, comparative perspective on emerging issue. First, allow me to extend my warm greeting to Prof. Dr. Joni Emirzon as a Dean of Faculty of Law, Universitas Sriwijaya, and Prof. Tim Lindsay. Are you join with us here, Prof? From University of Melbourne, Prof. Dr. Inyoman Nurjana, selamat datang. From Universitas Brawijaya, Dr. Hamonangan Albariansyah from Universitas Sriwijaya, Dr. Mahbubul Haq. Are you here, Prof?
Yes,
From
Malaysia.
University Sultan Zainal Abidin, Malaysia,
Yes.
and Prof. Andre Klip from Maastricht University, and of course all of five Dean here of the Faculty of Law, Universitas Sriwijaya, Bapak Jul dan Bapak Syaifuddin, lupa terus saya, maaf Pak. And the respected lecturers here, many lecturers here, and academic staff also. The organizing committee, I think it is a very high organizing committee, and of course all of the audience here, the participants here joining us today, both in person here, many students, and virtually, I think how many person that's joined by virtually. It is with immense pride that I stand here today on behalf of Universitas Sriwijaya as we host this international seminar. Sriwijaya, with its vision to be world-class university based on local wisdom, continues to foster global partnerships and advance academic excellence while remaining deeply rooted in the values of our community and culture. I hope this seminar amplifies our commitment to engaging with global issues such as evolving trend in criminal law and addressing them through meaningful dialogue and collaboration. The theme of seminar today aligns closely with our university vision. Criminal law today faces increasingly complex challenges, from transnational crime and human rights concerns to restorative justice and cybercrime. It is essential that we explore how different legal systems are responding to these issues, not just to learn from each other, but also to develop innovative solutions that are relevant in both local and global contexts. This seminar is an important step in achieving that goal. I would like to express my deepest appreciation to the Faculty of Law, Universitas Sriwijaya, for their tireless efforts in organizing these prestigious seminars, I think. I'm confident that insights shared today by our esteemed speakers will not only enhance our understanding about criminal law, but also contribute to development of more just and equitable legal framework globally. On behalf of Universitas Sriwijaya, I would also like to extend my gratitude to all the speakers and participants for your valuable contributions. May today's discussion inspire to continued collaboration and serve as a catalyst for innovation in the field of criminal law. Now, with great pleasure and honor, I declare that International Seminar on Exploring Global Trend in Criminal Law Comparative Perspective on Emerging Issue officially open. Thanks for your attention and have a nice seminar. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Professor Radianti Umipartan, for the opening speech.
We continue our agenda by opening session for seminar by our moderator, to Ms. Almira Novia Zulaika, S.H. M.H. The time is yours.
For the next agenda is group photo session and symbolic certificate presentation to Professor Tim Lindsay. With all the rector and all the lecturer here. To all the participants, you may stand up.
gua kalau Prof Tim udah join. Tolong kasih tahu kalau Prof Tim udah join. Tolong kasih tahu kalau dia udah join. Enggak, Pep, tolong kasih tahu aku kalau Prof Tim udah join. Tolong kasih tahu aku kalau Prof Tim sudah join, bilang Deso cepat. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, esteemed speakers, distinguished guests, and participants both online and in person. My name is Almira, Novia, Zulaika, and I am honored to serve as your moderator for today's international seminar organized by the Criminal Law Department of the Faculty of Law Universitas Sriwijaya as part of our 64th anniversary celebration. Our theme today is exploring global trends in criminal law, comparative perspectives on emerging issues, and we have an exceptional panel of speakers who will provide rich insights into criminal law from different regions of the world. This is a unique opportunity for us to dive into global comparative perspectives and discuss how criminal law is evolving to meet today's challenges. So, this seminar will bring us to lead voices in criminal law, allowing us to explore how different legal systems around the world are responding to the complex challenges posed by transnational crime, human rights issues, and the evolution of justice systems. And now, to officially begin our seminar, I would like to check if our first speaker, Professor Tim Lindsay, is it online on Zoom? Good afternoon, sir.
Good afternoon.
Okay. Professor Tim Lindsay, is it clear? Our sound
Yes,
here,
very clear. Thank you very much.
Okay, so I do apologize because your voice is not appear in our Zoom.
Can you hear me now?
Oh yeah. Okay, all right. Before we move on to the presentations, I would like to give a special acknowledgement to Prof. Tim Lindsay. I would personally like to say a quick hello as I am planning to pursue my Ph.D. under your supervision at the University of Melbourne, and it is a privilege to have you here today, and I look forward to working with you in the future. So let's now proceed to Prof. Tim Lindsay presentation on the Sustainable Development Goal 16, a criminal justice case study. But before we start the presentation, I would like to share the short biography of Professor Tim Lindsay. Professor Tim Lindsay is one of Australia's leading experts on Indonesian law and has advised governments, business, international organizations, courts, and legal practitioners in Indonesia and Australia. He is Malcolm Smith Professor of Asian Law, Redmond Berry Distinguished Professor and Director of the Center for Indonesian Law, Islam and Society at the Melbourne Law School. He holds a Bachelor's of Laws, Bachelor's of Arts, and Bachelor of Letters from the University of Melbourne and completed his Ph.D. thesis in Indonesian Studies. A specialist in a wide range of aspects of Indonesian law, including public law, criminal law, commercial law, and family law, he also teaches and researches Sharia, or Islamic law, in Indonesia and Southeast Asia. He has won national and university teaching awards and was an ARC Federation Fellow from 2006 to 2011. Prof. Tim is a member of the Victorian Bar and was the long-serving chair of the Australia-Indonesia Institute until 2016, and his more than 100 publications include Indonesia like Law and Society, Islam Law and the State in Southeast Asia, and the three of them is executive editor of the Australian Journal of Asian Law. So we now begin with the presentation of Prof. Tim Lindsay. Operator, can you please show up the presentation? Okay, thank you. To Prof. Tim, the time is yours.
Thank you very much, Almira. And let me just begin by saying it is a really great pleasure to be speaking to you all in the Prof. Amzulian Rifai Hall, because Prof. Amzulian was my master's student here at Melbourne University Law School many years ago and a good friend. So it is a real pleasure to be speaking in his hall. Thank you for inviting me to your conference today. It is a great pleasure to be here. I want to speak to you today about criminal justice and criminal injustice in Indonesia, Sustainable Development Goals 16. Sustainable Development Goal 16 is for peace, justice and strong institutions. Can we have the next slide, please? Thank you. Promote the rule of law at the national and international level and ensure equal access to justice for all, and develop effective, accountable and transparent institutions at all levels. Now, these are not easy objectives to achieve, and very few countries have been able to fully achieve them. But today I want to examine Indonesia's progress towards achieving this goal 16, which it has committed to. And to do that, I will use a criminal justice study involving a case I jointly researched with LBH Masyarakat in Jakarta, which works specifically on the death penalty, hukuman mati. Next slide, please. On 17th of May 1995, the Tembilahan District Court in Riau sentenced an uneducated, poor and illiterate farmer from a remote village called Sakak bin Jumak to death for the murder of another villager and his wife and child. In September that year, Sakak was transferred to Cipinang prison, where he was placed on death row, pending execution by a firing squad. He filed 2 clemency applications and both were rejected. He remained on death row for the next quarter of a century, waiting for an execution that never took place. Like many other prisoners who are left in limbo, forgotten on death row for years, Sakak's mental and physical health deteriorated severely over time. 20 years after he'd been convicted, LL.M, Lembaga Bantuan Hukum Masyarakat, began to represent Sakak. But in July 2020, they were told by the prison, Cipinang prison, that Sakak had died in August 2020 due to malnutrition and limited access to medical services in prison as a result of the pandemic. As his family could not afford to bury him, his body was disposed of by prison authorities. Now, there have to be serious doubts as to whether Sakak was guilty of the crime he was convicted of, or at least the level of his involvement in those crimes. As I will show, these doubts, these questions were not properly addressed during the criminal process to which he was subjected. This was largely due to repeated failures to respect Sakak's rights at Indonesian law as a person accused of a crime. And these failures included a lack of proper legal representation, the overlooking of his rights as a suspect, and an unfair trial, unfair procedurally and unfair substantively. And even if Sakak did commit the terrible crimes he was convicted of, his punishment, being left forgotten on death row for a quarter of a century, exceeded what was appropriate as a punishment. In all, the case of Sakak raises important questions about the fairness and integrity of the criminal justice system, and in particular, capital punishment. It raises questions about whether the Sustainable Development Goal 16 criteria of rule of law, the right to equal access to justice. Please go back. You've gone too far forward in the slides. Just keep going back.
to slide.
Slide 2. I'll tell you when to change. Yeah, I'm still on. I'll tell you when to change. The best way to demonstrate whether criminal justice institutions in Indonesia match the Sustainable Development Goals 16 criteria or rule of law is to explain to you one by one the rights that Sakak had according to Indonesian law and how they were ignored or marginalised from the day he was arrested until the day he died. Next slide, please. Thank you. A full understanding of what happened to Sakak is made difficult by the fact that proper records regarding the pre-trial process he went through and his trial are missing. This is despite Pasal 72 of KUHP, which states that at the request of a suspect or legal advisor, the official concerned shall provide a copy of the report of the examination, that is, the questioning by the police, for the purposes of his defence. Now, this right should operate for the benefit of persons who are suspects, but it often does not, for two reasons. First, under Pasal 72, the police report, that is, the report of the examination, is only to be provided in response to a formal request by the accused person's lawyer, and that request is often just ignored. Second, even if the report is provided, it is often not a true and complete record of the questioning. Pasal 143 ayat 4 of KUHP adds that copies of the letter submitting the case together with the letter of indictment, the dakwan, shall be provided to the suspect or the holder of his power of attorney or his legal advisor and the investigator at the same time the case submission letter is given to the district court. Now, this letter includes the surat dakwan and the case file, and its submission to the court is what leads to the case being set down for trial. This pasal is meant to ensure that all the material relevant to the case against the accused is given to him or her so that a proper defence can be prepared. In Sakak's case, Sakak and his original lawyer were first of all never given copies of the police investigation report, which was said to contain a confession by Sakak. He never saw this. And a copy of the prosecution submission letter to the court was never provided to Sakak. Copies of the investigation report and the police submission letter and all the material included in them have never been located. They seem to have been destroyed. Sakak also never received a copy of the decision of the Pengadilan Negeri Tembilahan, the decision by which he was sentenced to death. Pasal 226 ayat 2 of KUHP says that a copy of the court's putusan or verdict shall be given to the public prosecutor and the investigator, while to a defendant or his advisor it shall be given upon request. In other words, a defendant has to ask for a copy of the court's decision. This seems to be contrary to Pasal 52 ayat 2 of Law 2 of 1986 on the General Courts, which says that the court has to give a copy of that decision to all the parties within 14 days. So Sakak never received a copy of the decision by which he was sentenced to death. Eventually, a copy of the court's judgment, which was very hard to read, was found by L.M, and this became the only document that showed Sakak's arrest, questioning and trial. But like many Indonesian court decisions, it is not very useful for understanding what happened in the court. This is because of Pasal 197 ayat 1 of KUHP. And this sets out what judges must include in their court decision in a criminal case. It says what must be in the judgment. But if you look at that pasal, it does not require the court to record what the arguments of the defence were. So the decision, very hard to read, very damaged old decision in Sakak's case, in any case does not actually explain what the defence case was. It just gives it a few sentences. Now, the absence of these records of Sakak's questioning or of his trial, and the fact that the police and the court never provided Sakak or his lawyer with the records made it very difficult for L.M. to decide whether his rights as an accused person had been respected, although as you'll see, I think it's very unlikely that they were. Go to the next slide, please. So first of all, the right to legal advice. Sakak said that he was not legally represented during police questioning. This is a breach of Pasal 58-56 of KUHAP. The right to legal advice is established by Pasal 54, which says that for the purposes of defence, a suspect or a defendant has the right to obtain legal assistance during the period at every level of examination. And Pasal 55 says that the defendant has the right to choose his or her own legal advisor. Now, please, thank you. More importantly still, Pasal 114 says that in the event the person is suspected of committing a criminal act, the investigator is obliged to inform him of a right to legal assistance and that he must be accompanied by a legal advisor in this case, as stated in Article 56. So it's clear that there was a right to legal advice, but in reality these rights are very weak. Many people who are detained by the police in Indonesia do not have a lawyer present during questioning. This is because the police often do not tell them about their right, although they are legally obliged to do so, and so many are unaware of it. Likewise, many detainees report that police threaten violence or tougher penalties if they do get a lawyer. So many decline to have a lawyer even if it is offered. They refuse, afraid that they will be punished for it by the police. But in some circumstances, including in death penalty cases, that is a case where a death penalty could be imposed, the presence of a lawyer at a police questioning is mandatory. Pasal 56 ayat 1 says that where someone is charged with committing a criminal act that attracts the death sentence, the official concerned at all levels of examination in the judicial process must appoint a legal advisor for them. And it also says that legal advisors must be provided free of charge to the suspect or defendant. In other words, Sakak had an absolute right to have a legal advisor present from the police questioning onwards because he was facing a possible death sentence, being questioned about murder. Now, unfortunately, KUHAP does not deal with how such an appointed lawyer will be paid for their legal services. And this is a disincentive for many lawyers that the court can appoint for poor defendants, and it means that the quality of representation they provide is often very low. Even where an experienced legal advisor is available, the lawyer's ability to assist the accused person is limited by Pasal 115 ayat 1 of KUHAP. This says that when an examiner is examining a suspect, the legal advisor follows the examination by watching and listening. Now, this seems to limit the role of the lawyer to being a passive role, and it is common for a lawyer to simply be present and not allowed to speak at all. And some lawyers even refuse to advise their clients, even if they're offered the opportunity. And this is true even in death penalty cases where the quality of defence provided by free and often unpaid legal counsel is often very disappointing. As Harahap, a famous Indonesian judge and lawyer, almarhum Harahap, has written, these lawyers, quote, seem to lack motivation, unquote. In any case, at the end of the questioning, the accused person is usually asked to sign legal assistant minutes. This is later to be provided to the judge at the trial to show that a lawyer attended the accused's questioning by investigators. However, the accused's signature on these minutes does not necessarily mean he or she actually did receive any legal assistance. In Sakak's case, an Indonesian language statement signed by him with a fingerprint was presented to the court as evidence of his confession. Now, this confession was essential to the prosecution and his conviction, and the court relied on the confession in his judgment. But there has to be great doubt as to the validity of this key document for at least two reasons. First of all, the confession was obtained by police without Sakak being legally represented, and it is mandatory to be legally represented in a death penalty investigation. Secondly, Sakak could not possibly have understood the document he signed, as he was illiterate. He could not read or write. He could not even speak Indonesian language, and he was provided with no interpreter or translator, despite his clear rights to them. The fact that he was illiterate was shown that he signed with a fingerprint. So he was required to sign a confession he could not read in a language that he did not understand. His confession was worthless, and yet it was the basis of his conviction. Next slide, please.
Next slide.
So the use of this purported confession is also concerning because, according to Sakak, it was obtained as a result of beatings. Sakak told L.M. that he was beaten until he agreed to put his fingerprint on the document. I mean, this is obviously wrong, and it's in direct contravention of Pasal 52 of KUHP, which says that the suspect or defendant during investigation and trial has the right to give information freely to the investigator or judge, that is, without duress, that is to say, without being forced. And on his account, Sakak was forced. But even if he wasn't forced, the fact that he could not read or understand his confession, and there was no lawyer present when a lawyer was mandatory, meant that the confession was worthless. Next slide, please. Thank you. I want to look now at the right to an interpreter. Pasal 51 of KUHP makes it clear that for an accused person to prepare his or her defence, he or she has the right to be clearly informed in a language that he or she understands about what the claims are against him or her and the charge brought against him or her. Pasal 177 ayat 1 of KUHP adds that if the defendant or a witness does not understand the Indonesian language, like Sakak, the judge must appoint an interpreter who shall give a promise to truly interpret all that has to be interpreted. In other words, if the person in question can't speak or understand Indonesian, then it's up to the judge to appoint an interpreter. But in practice, judges usually don't do this unless they are requested by the prosecutor or a defence lawyer. And that is because there is no law which clearly states who is responsible for paying the interpreter. Sakak could, as I said, could not speak Bahasa Indonesia at the time of his arrest. Despite this, the police investigations and the court proceeding, his examination, the persidangan, were all conducted in Indonesian, and Sakak was never given an interpreter or translator. Even if the police had used a language that Sakak understood when questioning him, he could not read, and so he could not have understood the documents he was asked to read or sign, including his confession. In short, Sakak's right to be clearly informed in a language he understood of the allegations and charges against him was completely ignored. Throughout the legal process, the police investigation and the trial that led to him being sentenced to death and left to die on death row. Next slide, please.
Next slide, please.
Thank you. Indonesian, that's it, yes. Indonesian laws do not clearly establish a right to a fair trial, but it is possible to find a similar right in Bab 10A of the Indonesian Constitution. For example, Pasal 28D ayat 1 of the Constitution recognises the right to legal recognition, guarantees protection, certainty and equal treatment before the law. Pasal 27 ayat 1 repeats the right to equal treatment before the law. And the Mahkamah Konstitusi has also said that because Indonesia is a negara hukum, a state subject to the rule of law, therefore due process is imperative. These are very important protections, they are important rights, but they are not the same thing as a clear constitutional or legal guarantee of a fair trial. More importantly, there is no judicial remedy for a failure to respect a constitutional right in Indonesia. Only a right to ask the Constitutional Court to review a statute, an undang-undang contrary to the Constitution. You cannot ask the Constitutional Court to repeal or reverse a decision that involves a breach of a constitutional right, decision by a court or by government. The Constitutional Court cannot do that. Next slide, please.
Yes, Prof. This is the slide.
Thank you.
Before, okay.
This is this one. Thank you. I'll just leave that slide there. Indonesian statutes do contain some procedural safeguards intended to protect the rights of suspects and defendants at trial, but there is no clear statement of a right to silence. As well as a right to counsel, the other rights of suspects include the presumption of innocence and the right to be free of the burden of proof. But again, none of these things are the same thing as a right to a fair trial. But even if let's just assume there is a basic right to a fair trial, that is, to equal treatment before the law and so on, there are at least two strong reasons to doubt that this right was suspected in Sakak's case. First, as mentioned, he was not given an interpreter at trial. And second, he seems to have received very bad legal representation. It appears he was represented at trial by an apparently unpaid lawyer appointed by the court, but that lawyer seems not to have asked for an interpreter or opposed the prosecution's reliance on the purported confession. The failure to raise these issues at trial made it almost impossible for Sakak to avoid conviction. Now, Sakak could have appealed his conviction to the Pengadilan Tinggi in Riau. Under Pasal 233 ayat 2 of KUHAP, the time limit for a criminal appeal is 7 days. But no appeal was lodged. It was still open to him to seek peninjauan kembali or PK from the Mahkamah Agung, but Sakak did not make an application for a PK because no one told him he could. He didn't know he could appeal, and he didn't apply for a PK because his lawyer didn't tell him. This meant that his only remaining remedy was clemency. Can I have the next slide, please? Thank you. An unknown person, probably the trial lawyer, lodged a clemency application on Sakak's behalf just 9 days after the Tembilahan Pengadilan Negeri decision without telling him. This was 2 days after the deadline to submit an appeal to the High Court had expired, which suggests that Sakak's lawyer had made a decision just to abandon Sakak's right to appeal and reconsideration and instead rely on clemency. The reasons for this are not clear, but filing the clemency application marked an end to the judicial process and probably freed the lawyer from further responsibility for Sakak. This may have been a motivating factor for a court-appointed lawyer who was probably not paid. This is supported by the fact that the application, which again Sakak signed with just a fingerprint, was very brief. 1 page with just 4 lines of writing, 4 lines of argument. The clemency application was not dealt with for years until August 2000 when it was rejected by President Gus Dur. But a copy of the decision was never given to Sakak and in fact has never been provided by the government ever, despite its requests by LL.M. In any case, once Wahid's decision, even though Sakak was made, even though Sakak didn't know, the government could start the process leading to execution, but it didn't. It just left him sitting on death row, waiting for something to happen for 20 years. 2 years after his first clemency application was rejected, another one was filed by an unknown person. This document was as short as the other one, just 4 lines. And this time, however, the application had with it also a lawyer from Dr. Albert Hasibuan of Komnas HAM, who said that his investigation had found that Sakak had been poorly represented, that the lawyer provided by the state at the trial had not been given a copy of the judgment in the case and hadn't appealed. And he said that the clemency should be taken seriously because of the poor representation Sakak had had. Despite this, L.M. was told by government officials that Sakak's second application was rejected by President Megawati. But again, a copy was never given to Sakak. He never received a copy of the presidential decision for either clemency decision. And this is despite the fact that Pasal 12 of the clemency law requires that when clemency is refused, information about the refusal must be given to the prisoner within 14 days. In fact, no copy of the decisions of Gusdur or Megawati have ever even been found in government records, notwithstanding freedom of information requests made by L.M. This is important because Article 13 of the Clemency Law says that a prisoner who has received the death sentence and applied for clemency cannot be executed until he or she receives a presidential decision rejecting the application. In other words, Sakak was trapped. His clemency decisions had been refused, but no copies had been given to him. And therefore, under Pasal 13 of the Clemency Law, he cannot be executed. He could not be freed, he could not be executed. Without it, the condemned prisoner just sits on death row, getting physically and mentally sicker and sicker, as did Sakak. He was suffering from something that is known as death row syndrome, and investigations by psychologists and criminologists have shown that the form of punishment imposed on a prisoner on death row who has no notion of when or if he'll be executed, no notion of what has happened to the legal process involving him, no notion of whether his clemency applications have been refused or granted, creates severe mental illness and greatly aggravates the punishment of imprisonment. So, final slide, please. The flawed legal process of a police investigation and then a trial in which basic rights guaranteed to Indonesians by KUHP, law and criminal procedure, were simply ignored, mainly because Sakak was poor, illiterate and ignorant. This flawed legal process that led to him being convicted, sentenced to death and then left to die on death row is a reminder of the problems of criminal justice in Indonesia. I've spent a lot of time looking in detail at this case, a little-known case involving a powerless poor person in a distant province. I've looked at it in detail because this case demonstrates problems that occur commonly at every stage of the criminal justice system in Indonesia and occur daily to poor and marginalised prisoners on a routine basis during police investigation and trial across the country. Regardless of whether they are guilty or innocent, individuals like Sakak have very little power to exercise their rights and obtain procedurally and substantively fair treatment from law enforcers. And this means they are vulnerable to abuse and neglect. The law is like a knife. It is sharp cutting downwards and blunt cutting upwards, as the Indonesian saying has it. For Indonesia to move closer to achieving the Sustainable Development Goal 16 by fulfilling the rule of law and the right to equal justice for all, and ensuring its criminal justice institutions are effective, accountable and transparent, basic criminal law reforms are needed. And these reforms would include, first, clear and effective remedies for breaches of procedural rules in KUHP, including penalties for those who breach them. At the moment, the procedural rules are there in KUHAP, but there are no clear penalties for those who breach them. There are no consequences if the laws are ignored. Now, a rule without consequences is not really a rule. Secondly, there need to be clearer rights to legal representation, provision of legal documents and interpreters, again, with consequences. For example, that a prosecution cannot proceed if those rights are breached. Thirdly, there need to be clear rules about public funding for state-provided lawyers and interpreters for poor defendants, or for defendants who do not speak Bahasa Indonesia. It is one thing just to allow judges to provide interpreters, but it is another thing to have funding to fund those interpreters. If there is no funding for interpreters, then none will be appointed. And if a person cannot understand the language in which they are being put on trial and with their life at stake, then that is not justice. Fourth, new rules of evidence are needed to prevent courts using evidence obtained from investigations where procedural rules have been broken. The best way to force police to comply with procedural rules are to say that evidence obtained when procedural rules are broken cannot be used in court. Without that requirement, procedural rules don't have much meaning. The clemency law also needs to be reformed. There are problems with decisions being delayed for inordinate and extreme periods, and there are problems with people waiting for a result not being advised about the outcome. Above all, a constitutional guarantee of procedurally and substantive fair trial should be inserted into Indonesia's constitution, with a clear right to judicial relief, in other words, a right to go to court if that right to a fair trial is violated. And that right and relief should also be enshrined in a statute. It should also be a grounds of appeal that a fair trial was not granted. Finally, prisoners who have been left on death row for more than 10 years should have their sentences commuted to life or 20 years. The evidence by experts, criminologists and so forth, that imprisonment without clarity about the future on death row for more than 10 years creates severe mental and indeed physical illnesses. Someone who is abandoned for 10 years on death row should have their sentence commuted to a clear term of imprisonment, so they have certainty. Now, happily, that reform has been included now in Indonesian law and is in the new criminal code, the KUHP, which will come into effect in 2026. That new criminal code has some very big problems. But one of the good things is that in the future, people who have been abandoned and forgotten on death row and have been of good behaviour will have the opportunity of their death sentence to be reduced to a clear term of imprisonment. And that will end a great deal of injustice. But that's not enough. All of these reforms are needed and they must be enforced and made real if Indonesia is to fulfil Sustainable Development Goal 16, a goal it has committed to. Thank you for your attention today.
Thank you so much, Prof. Tim Lindsay, for such a profound and insightful presentation. Your deep understanding of Indonesia's legal system and your ability to communicate these complex issues in both English and Bahasa Indonesia, thank you so much, continues to greatly influence and inspire the legal community here. Before we open the floor for questions, I'd like to briefly summarize the key points from Prof. Tim Lindsay's presentation. In his discussion of Sustainable Development Goal 16, Prof. Tim highlighted critical challenges within Indonesia's criminal justice system, particularly the case of Sakak bin Jumak, which raised concerns about access to justice, fairness, and transparency. Despite Indonesia's commitment to SDG 16, the system faces significant gaps in legal representation, documentation, and clemency procedures. Prof. Tim emphasized the need for urgent reforms to ensure stronger rights to legal assistance, clearer pre-trial and appeal process, and better protection against prolonged death row sentences. Achieving the goals of the SDG 16 in Indonesia will require serious legal reforms to provide justice for all and develop accountable institutions. Now, we'd like to open the floor for questions to Prof. Tim Lindsay. For those of you here in person, if you have a question, please raise your hand and our team will bring a microphone to you. And for our participants online, feel free to type your question in the Zoom chat and I will read them out on your behalf. We encourage everyone to take this opportunity to ask questions and dive deeper into today's discussion. Thank you. So please, yeah.
First thing first, thank you very much, Professor, for attending this. This is such a great opportunity for me because it's so exciting to see someone from outside of Indonesia tell story about Indonesia. I have two questions for you. First question is one of the topic I really like, which is moral code. Moral code in law, basically. And this case, Saka's case, it's a dilemma. I would like to say it's dilemma because the moral code, it's followed and ignored at the same time. What I mean by followed is that as far as I know, Indonesia is never executed a death sentence, as far as I know, because it's broke the moral code of human rights. But in this case, it's clearly that Saka case, he writes, it's not followed. So the moral code, it's broken because it's not been followed and it's not represented as good as he's supposed to. So my question is, what's the line between the supposed moral code in every criminal law in this world, basically? What's the line? What's the perfect line of government that should take to at the same time followed and not broke the code? And the second question is, Professor, what time is it? What time is it in Australia? Thank you very much.
Okay. Thank you so much for. What's your name, please? What's your name? Sorry.
My name is Falik Endria Zubahda from the Faculty of Law, Universitas Sriwijaya, Kampus Indralaya, Angkatan 23. Thank you.
Okay, thank you. Please give applause to Mr. Fari. So, to Prof Tim, you can answer by. Okay, the time is
Thank
yours.
you. Thank you for your question, Farik. It is now 4:37 p.m. in the afternoon in Australia. And luckily, it is a musim semi at the moment, so it is not cold and raining, because it usually is cold and raining in Melbourne. But today it is a lovely warm day, and unfortunately I am in a room talking to you on Zoom instead of sitting in the park. And that's a problem because I can see a park from my window. But look, thank you for asking. Australia is 4 hours behind, 4 hours ahead of Indonesia for half the year, and the other half of the year it's 3 hours ahead. So if you come and study in Australia, you will be able to keep in touch with your families quite easily. That's a periklanan for study in Australia. Now, turning to your other question, thank you, about moral code and procedure code. A moral code is always problematic in law because inevitably there is a debate about morality. And you will never find in any community complete agreement on morality. There is always great disagreement. That is a problem when a crime is committed that involves morality. For example, a sexual offence, or even an offence of violence may involve questions of morality, self-defence and so on. So, in my view, morality is a dangerous thing in the law when it comes to criminal procedure and substantive justice. And the aim of criminal procedure is to avoid questions of morality as much as possible. The solution is not to rely on morality, but to rely on rigid procedural rules that are designed not to form a moral judgment, but to ensure fair and equal treatment of people regardless of morality. Now, that only works if you have a set of substantive rights, a mechanism in legislation and regulation that establishes standards for those rights, and then a means of enforcing those rights. To be clearer about what I mean, if you have a provision that says that a person who does not speak the language in which the trial is being conducted must have an interpreter, that's a right, and it's not a moral right, it's an absolute right that is given to all defendants regardless of their morality. But the question then becomes, what happens if that right is ignored? And if there is no consequence or no punishment or no way in which the holder of the rights can enforce the rights, then those rights are not really rights at all. They are standards, not rules. So procedural criminal law is extremely important because it is the mechanism that guides people against being the victims of moral difference of opinion. For example, where a policeman or a judge or whoever is involved thinks a person is morally wrong and wishes to punish them, then they will ignore their rights. So you need to have a very strong procedural system in order to guarantee those rights, and that procedural system will only work if it includes punishments and consequences for those who breach them. And really, when it comes to criminal prosecution, the only effective right is that a criminal prosecution has to be halted if guaranteed rights are not respected. In other words, a failure to respect a right, for example, to have an interpreter during a trial means that the prosecution must fail. Now, that may be unfair because a person may well have committed a crime, and it may well be that there's a mistake made in all honesty and the person is released from responsibility for that crime, but in fact it is the only way to ensure that law enforcers will respect the right. So, I mean, I suppose the short answer to your question is actually that it's not a question of morality, it's a question of enforcing procedural rights with consequences, and the consequences are acquittal where a law is breached. And unfortunately, that does not happen in the Indonesian system.
Okay, thank you. So, Mr. Farid, is it clear to your question? Thank you so much, Prof. Tim. So, the next time, if you want to go to Melbourne, you can join me to go to Melbourne to meet the Prof. Tim Lindsay in person, I guess. So the next one, the next question. Okay, this one.
Introduce myself. My name is Jusniar Saputra from Faculty of Law Universitas Sriwijaya and as a member ALSA Local Chapter Universitas Sriwijaya. Good afternoon, Professor. In the new criminal code, the death penalty is given a 10-year gap before the convict will be executed. My question is, according to the professor, is the provision occurs while the Sakak case is still ongoing? Will it fulfill a sense of justice for Sakak? Thank you, Mas Professor.
Thank you very much for your question. Yes, that's right. As I mentioned at the end, the new KUHP does introduce this 10-year opportunity for a reprieve. In other words, if the prisoner is on death row waiting conviction for 10 years and has been of good behaviour, then the sentence can be commuted to a fixed term of 20 years or less, or it can be life. Now, that was a proposal that was made by the Mahkamah Konstitusi in a decision about the death penalty some time ago. And it was recommended, although that the Mahkamah Konstitusi upheld the death penalty, it recommended that the DPR should introduce a system where there could be a reprieve, a reduction of sentence after 10 years. And eventually that has been included in the new criminal code. As I said, there are a lot of problems with the new criminal code, but that is one of the good provisions. Now, that is an idea that is actually used in some other countries. China, for example, has a similar provision in its criminal code for death sentences. The advantage of it is that it means that people are not put on death row and forgotten, as in Sakak's case for 25 years. It means that automatically, after 10 years, a review can be had of their conduct, whether they've been in good behaviour. If it had applied during Sakak's time in prison, he would not have still been there for 25 years. After 10 years, because he had been a prisoner of good behaviour, he would have had the benefit of that and would have been given a definite term of imprisonment. At the most, if he hadn't received life, he might have received 20 years, and that means he would have been released before the time he ended up dying. So the real advantage of that is that the experts who look at death row syndrome have made it quite clear that it is the uncertainty of a prisoner's fate, waiting for year after year, decade after decade, without knowing whether they will be released from prison in the future, whether they'll be executed tomorrow or in 10 years or 20 years. It's that uncertainty that causes death row syndrome, the form of mental illness that is very common for prisoners left on death row. So the advantage of this 10-year good behaviour reprieve system is that it gives the prisoner only has to wait 10 years. They have certainty that at that point the future for them will be decided, and they will know then exactly what their term of imprisonment will be. And yes, that would have resolved a lot of problems.
Okay. Thank you so much, Prof. Tim, for your really insightful answer for our student Jusniar. Is it clear for the answer? Okay, thank you. So there is question more for Prof. Tim?
There is one online from Jefferson.
There is one online? Okay. The online from the Zoom chat or?
No, one of the Zoom audience has a hand up. Yeah.
Yes. Okay, the time is
Thank
yours,
you, Prof.
sir.
Thank you, Ibu Moderator, and thank you, Professor Lindsay. It is fantastic to see you, and you have delivered very brave legal research result that surprised me, actually, if you like, Professor Lindsay. You measure the Indonesian criminal procedural law, our KUHP, with a goal number 16 of SGD. The point you use has been access to justice. And the method you used was a case study, and you choose a Sakak case. And this is interesting. You have found that in Sakak case, you deliberately found that our KUHP, especially the right.
Master, if you have a question, do you mind to ask the question directly, because of the time of Prof. Tim is very, yeah.
Okay.
Please the question directly. Thank you.
Okay, Professor Lindsay, thank you, moderator. Do you recognize, for example, discretion in a legal system that maybe we can use to solve the problem of giving the right to Sakak, for example, to be granted money by the government, maybe by the police or by the public prosecutor or by the judge, to give the money to pay for the interpreter, for example, in the Sakak case. In this case, maybe this will solve our problem, because we have failed to fulfill the goal number 16 in this case. So we are a failed nation in this case, Professor Lindsay. Thank you very much for your kind to answer this question. I'm sorry for my English language. Thank you,
No,
Prof.
your English is fine. Pasti lebih baik daripada bahasa Indonesia saya. But Jefferson, it's a good question. So the answer to your question is that there is no point, that there is a legal requirement for an interpreter or translator to be provided, but that legal requirement means nothing if, first of all, there are no consequences for ignoring it. So it is a basic principle for lawyers that a rule that does not have a consequence is not a rule. And there's no real consequence for ignoring the procedural requirements in KUHAP. That's the first thing. Secondly, it's not clear how a court can actually fulfill those requirements given there is no proper funding for interpreters or translators. And Sakak's case is not a unique case. I chose it because I was working with LL.M on this case before Sakak died, so I became very familiar with the case. But I also chose it because the problems he encountered are very common for poor and marginalised defendants. And they will continue to be problematic if there's no funding provided for translators and interpreters. And unfortunately, this problem of people being sentenced to death without understanding the language of the court in which they are being tried is not just something that happened in Sakak's case. There are lots of cases where people have been sentenced to death in Indonesia and they have not been able to speak Indonesian and they have not been given interpreters or translators, for example, foreigners. So I don't think Indonesia failed. I think the judges in this case and the police in this case failed. And the reason they've failed is because legislators failed to provide consequences in KUHAP for breaches of rights. And why did they fail? Why did legislators not put consequences in KUHAP? The answer is that this was a law passed in the Orba, Masa Suharto. It was not meant to be a serious criminal procedure law. It was not meant to work. Now, this was, kalau tidak salah, tahun 81. It was at the Puncak Orba. And it's about time in this era pasca Suharto that Indonesia reformed KUHAP the way it's reformed the KUHP. Hopefully it does a better job with KUHAP than it has done with the KUHP. Thank you.
Thank you, Prof. Timlinsi. Please give us applause to Prof. Timlinsi and all of us here, whether in person or in online by Zoom. Thank you, Prof. Timlinsi, for your enlightening presentation and for the delightful sharing during the question and answer session. And considering the different time zones and your busy schedule, we will need to conclude this session. And on behalf of my Dean, Professor Dr. Joni Emirzon, M.Hum, and my former Dean, Professor Amzulian Rifai, LL.M, Ph.D. We truly appreciate your participation in this seminar, and we hope to see you soon in person, whether in Melbourne or in Indonesia. As a token of our gratitude, we would like to invite everyone for a group photo session to commemorate this event. And additionally, we will present you with a certificate of appreciation to symbolize our thanks for your contribution. And let's gather for the photo. The operator, please appear the certificate for Prof. Tim on the Zoom screen.
Yeah, Almira.
There it is.
Yeah.
Prof. Tim.
Thank you.
Prof. Tim. Thank you. Yeah.
Prof. Tim.
Prof.
I
Tim.
do apologize because there is our Dean on
Prof.
online
Tim.
Zoom.
Almira.
Oh yes.
Yeah.
Prof.
Tim. Yeah. I remember 30 years ago, Alip project. You remember? Yeah. I am.
Oh yes.
Yeah, I'm a young lecturer at the time. Thank you, Prof.
Thank you. It's a pleasure to be meeting with all of you, with all of my friends at Universitas Sriwijaya, and I hope more of you will follow in the footsteps of Prof. Amzulian and come to Melbourne to do your S2 atau S3 di sini.
Yeah, well, the S3 di Melbourne. Thank you.
I'd like to see more alumni dari UNSRI.
Yeah. Okay. Yeah.
Thank you. So, Prof. Joni, would you like to give the certificate to Prof. Tim because you are in Zoom right now?
Yeah.
Operator, we can start the symbolized certificate to Prof. Tim Lindsay. Please appear the layer of Prof. Tim Lindsay, Prof. Joni, and also the certificate in online. Thank you.
Yeah. I hope receive this the speaker problems. Yeah. The next time we hope.
Yeah, I look forward to it. Thank you very much. Thank you, Prof.
So, operator, is it? Yeah, okay. Thank you. So, we can take a photo first. Prof. Joni. Okay. Okay. Prof. Tim and Prof. Joni, we would like to take a picture of you beside the certificate. Professor Tim Lindsay as a speaker. 1, 2, 3. So you can give the L sign. The L sign, yeah. Prof. Joni, could you give us the L sign? Okay. 1, 2, 3. Great. Thank you so much. Please give us the applause for Prof. Tim Lindsay and also Prof. Joni. Prof. Tim Lindsay, thank you so much for your presentation and your share today. We would like to meet you in person next time in the future. Thank you so much.
Thank you very much, everyone. Thank you, Ibu.
You're welcome, Prof.
Your moderating and your kesabaran yang luar biasa.
Yeah, Prof.
Sampai ketemu di UNSRI atau di Universitas Melbourne.
Melbourne, yeah.
Thank you so much, Prof. See you soon.
Okay.
So,
and I just want to say, all the students out there, harus rajin.
yeah.
Yeah, Prof.
Sure, Prof.
Okay, ma'am. Sure.
Yeah, thank you. Bye-bye.
Thank you so much, Prof. Okay, that's perfectly fine if Prof. Tim need to leave us soon, as we have other amazing speakers. We have Professor Dr. Inyoman Nurjaya SHMS. Could you please join me in front of here, Prof. Also Dr. Hamonangan Albarian Shah SHMH from Universitas Sriwijaya that join us in person, and the other one is Dr. Mahbubul Haq from University Sultan Zainal Abidin from Malaysia that joined us in Zoom online, and the last but not least is Professor Andre Klip from Maastricht University that will join us also by Zoom in virtual. Okay. To our student, if you have to make prayer time, you can go outside by one, and ask the committee to check your name to go have a prayer time. So we can start to the next session of our seminar today. Begin with Professor Dr. Inyoman Nurjaya SHMS from Universitas Brawijaya. Prof. Nyoman is an expert in Indonesian law with significant contribution to the understanding of restorative justice and integrated criminal justice systems, and his extensive experience in the development of Indonesia's legal frameworks will provide valuable insights today. So, we will have 30 minutes, Prof. You can tell us by English or Bahasa Indonesia is okay. So, before we start the presentation, I would like to share the short CV of Prof. Nyoman. Prof. Nyoman is Bachelor of Law from Faculty of Law Universitas Sriwijaya Malang on 1979, and Master of Law in Universitas Gadjah Mada Yogyakarta in 1985, and on 1989 Prof Newman also got a short course on legal anthropology for 6 months in Leiden University and Wageningen Agriculture University, the Netherlands, in behalf of Professor Dr. Frans von Benda Beckman and Professor Dr. J.S. Beckman. And the Ph.D. on 2001 in Universitas Indonesia, Jakarta, and got the professor in Faculty of Law, Universitas Sriwijaya Malang in 2006. So we begin with the presentation of the Prof. Newman. Operator, please appear the presentation. Give applause for Prof. Newman Nurjaya. Oke, silakan.
Thank you very much, Mrs. Chair Ladies and Moderator. Dear all participants, students, and all lecturers, Faculty of Law, Sriwijaya University, and dear invited speaker, Tim Lindsay, Professor Andri Kleep, Mahbubul Haq, and our college, Hamanangan. First of all, I would like to pray to Almighty God and greeting our religion. Assalamualaikum warahmatullahi wabarakatuh. Om Swastiastu, Salam, salam sejahtera untuk kita semua. Namo Buddhaya, Rahayu, salam kebajikan. First of all, I would like to convey my great appreciation to the Faculty of Law, Sriwijaya University, in organizing the international seminars on exploring global trends in criminal law. I think these international seminars is timely to discuss and to understanding the development of criminal law, and especially in criminal justice system in all the world, and on how the establishment of our criminal justice system in our country, Indonesia. My presentation will begin with the nature of criminal law and characteristic of criminal law, especially in the criminal justice system, and on how we have obtain another solution to handling a criminal in fairness and justice. Case within the criminal justice system, and on how the Indonesian criminal justice system will direct it to our mainly cultures and basic values of our culture. And at the end, I would like to explain and discuss whether the restorative justice, it is a new in our country, on our legal systems or not, because we have legal cultures in the system and in dispute settlement in our society. First of all, I would like to explain about the nature of criminal law and how the characteristics of criminal law. The extent of law is naturally to create and peace and such prosperity in society. Criminal law is employed conventionally. That is always through court channels, and criminal law has been recognized as a final measure, ultimum remedium, as to both legally resolve criminal cases and to force crime control in society. The essence of criminal law is the law that is intended to force harm and painful and penal sanction, punishment for the offenders. That is why criminal law is the so-called lex talionis in Latin. That is the law intentionally created to enforce suffering, sorrow, grief, pain, and harmful, and impose penal sanction to the criminals. Modern criminal law and justice, which priorities the personal mix as a human being. It is said that the law enforcement does not merely mean the implementation of criminal law. Accordingly, law enforcement is an activity. Is an activity to harmonize the relationship of values that outline in principles, in legal principles, that aim to create social order and maintain peace. The law must be progressive. That is, the law must be observed from the perspective of public interest and justice. It should be understood that a dynamic, because the public interest and justice always follows the progress of society. And the law has been a legal entity to aims to lead humans obtain peace in harmony, prosperous, and humans in justice. It is because the peace without justice is oppression, and justice without peace is a new form of pressure and persecution. The mainly problem is that the judiciary, pengadilan, has been patterned with the so-called retributive justice. That is the characteristic of criminal law that is intended to punish the people, giving a penal sanction to make the people sorrow. Retributive justice paradigm that views a crime, a violation committed against the state that criminal justice finally end up in prison. The prison is naturally not the best solution in solving problem of crime in society. It is because sentence confinement has negative impact such as enable the prisoners to exchange experience inside the prison, and the stigma of former prisoner is often acceptable in society. What have explained and discussed by Tim Lindsay, yes? He discussed about the system of criminal justice and criminal injustice system. By emerging the case of Saka, performing that the criminal procedure law in relation to the people who committed the crime, and really showing that the system of criminal justice absolutely having a injustice. Reason of overcapacity in many prisons encourage application of what the so-called penal mediation in the criminal justice. The dispute solution beyond the litigation can be a proper option to overcome the problem of crime in the criminal justice system, particularly for not all crime, particularly for the minor felony, kejahatan ringan, and misdemeanor in the form of penal mediation. Misdemeanor itu pelanggaran sebenarnya, lebih pada pelanggaran. Felony itu kejahatan berat, tapi ini minor. Ya, major, ini minor, pelanggaran ringan. It is meant that restorative justice can be employed for the selected crime. Not all crime can be approaching to have a solution in criminal case within the criminal justice system or the criminal enforcement system, sistem penegakan hukum. The law should be understood as human and not human for the law. That is why if the law for humans, then ways to taken to make humans harmonious profession in society, it need to establish a part of human effort to seek justice, including the settlement of criminal case through non-litigation channels. That is, or namely, restorative justice. As a solving problem approach to crime which involves the concerned parties, that is, victims and offender, and the community relationship with statutory agencies. Restorative justice commonly defines an approach and process whereby parties with a stake in a specific offense collectively resolve on how to deal with the aforementioned the offense and its implication for the future. Restorative justice may be seen as criminal justice embedded in its social context. It is recognized that the primary objective of restorative justice has been to attend the needs and interests of victims, namely materials, financial, emotional, and social, including personally who may be similarly affected. Restorative justice is centrally concerned with restoration of the victim and offenders, restoration of the damage caused by crime to the community, and it is concerned with the construction of a better society in the present and the future. Criminal justice system should be established in its practices by the restorative justice in order to achieve fairness in improvement and restoration after the crime occurred in society. This is in order to replace the retributive justice as a chaotic criminal law. Retributive justice not longer provides a saving result in prevention of crime. In other words, there is a high drive to switch to restorative justice in criminal justice system, in which the approach of restorative justice involves the concerned parties. There is offender, victims, the law enforcement officer, as well as the community, to create the best and fairness solution between criminal law and the victim. That is the essence of restorative justice, as to replace the retributive justice paradigm in criminal law, and especially in criminal justice system. The ultimate attention with regard to criminal justice system and management have actually been resolved by the 8th United Nations Congress of Prevention of Crime and the Treatment of Offenders, conducted in 1990 in Havana, Cuba. It is actually in line with the 2020 Declaration of the United States concerning the basic principles of the use of restorative justice program in criminal matters. The declaration includes a strong recommendation to approach restorative justice widely within the criminal justice system. It is therefore the restorative justice can be mentioned as a legal breakthrough, terobosan hukum, in approaching and mechanism of such criminal justice system. Implementation of restorative justice is to consider the purpose of reconciliation between victim and the offenders through mediation in settling criminal case, in order to return and repair the damage because of criminal case, to obtain the fairness and fairness solution for the best interests of victims and the offender. the criminal justice system should be considered and sensitive to social and cultural dynamic of society. It is therefore the law enforcement official should provide the constructive solution for the implementation of criminal justice system in the context of social change. That one of them is by employing the method of legal discovery toward humanity, justice for criminal law enforcement and management. How about Indonesian experience regarding this restorative justice paradigm within the criminal justice system in our country? For Indonesia, in particular, the integrated criminal justice system defined within the Act Number 8, year 1981, concerning hukum acara pidana. In the Article 7, stated that the police as investigation officer due to its legal obligation in special wars dalam keadaan tertentu situation if necessary can conduct the other acts need on their own consideration in accordance to police duty and responsibility. In detail, the authority has been defined in the Article 18, Law Number 2, year 2002, on the State Police of the Republic of Indonesia. That is stated that in the name of public interest, atas nama kepentingan umum, the state police can conduct according their own judgment. Dapat melakukan tindakan sendiri berdasarkan pertimbangan penilaiannya sendiri. The implementation of this particular provision can only be done in a dispensable condition, dalam keadaan tertentu saja, with due to observance of the state regulation as well the professional code ethics for the state police of the Republic of Indonesia. Tapi harus didasarkan pada undang-undang dan juga kode etik kepolisian. It could be understood that the police as a foremost officer in criminal justice system needs to employ discretion power. That is the basic foundation of restorative justice paradigm, discretion power. In a special situation, because the police role not the only as a law enforcement agency, but also perform its role in keeping social order and maintaining peace and harmony within the society. In relation to the restorative justice approach, in the state police regulation, number 8, year 2021, concerning criminal case handling based on restorative justice, is clearly defined that in order to maintain the balanced interests of victims and offender, families and the affected community as well, the court penal sanction and sentencing orientation can be ignored for the purpose of fulfilling balanced interests of the concerned parties in the sense of community justice. In the level of prosecution duty in the criminal justice system. Tadi polisi, sekarang jaksa. Ya, sebagai bagian dari law enforcement officer in the system, dalam sistem penegakan hukum pidana dan juga dalam sistem peradilan pidana yang terpadu. Untuk jaksa, in the level of prosecution task, penuntutannya, in the criminal justice system, according to Article 15, the law number 16 year 2014 concerning prosecutor of the Republic of Indonesia, the restorative justice approach could be applied by the chief of prosecutors in the form of what the so-called subpoenaing. There is two kind of discretion power in the prosecution level. That is deponeering and subpoenaing. Subpoenaing authority to dismiss prosecution criminal cases in the name of criminal law, atas nama hukum. Menghentikan penuntutan atas nama undang-undang. It is confirmed that the only certain criminal case, hanya untuk tindak pidana tertentu, can be discharged in the name of legal interest in order to seek protection rights and need of the victims and offender, and maintaining social order and legal order and the sense of community justice as well. The idea of penal mediation has long been practiced in the country of Indonesia, particularly in resolving criminal cases, in which such restorative justice approach that was one intent mentioned as traditional legal instrument is for now declared as a progressive approach in criminal justice system. In detail, the prosecutor regulation of the Republic of Indonesia, number 15, 2000, concerning prosecution discharge based on restorative justice, clearly define that prosecution officer should have capability to maintain social order, legal certainty, and the legal truth based on law and justice in handling criminal case in the stage of prosecution. It is therefore restorative justice approach can be employed for a particular criminal case, the only particular, hanya tindak pidana tertentu saja, to dismiss prosecution tasks in order to provide in priority restoring social order and harmony of the concerned community. How about in judiciary level, di pengadilan, di tingkat pengadilan? The restorative justice approach in the stage of court and tribunal can also be applied to the end certain criminal case. In this respect, the Act number 48 year 2009 regarding judicial authority, in Article 5 in particular stated that judges and constitutional judges should observe, follow, and understand such legal values in the sense of justice that alive in society. In Supreme Court Regulation number 1, year 2020, concerning guidance for criminal cases based on restorative justice application, mentioned that restorative justice is a legal option, pilihan yang terbaik in law enforcement principle that should be encouraged to apply in tribunal processes as an instrument to create balance interest and mainly victims' legal rights fulfillment and the other affected parties, as well as to recover, pace, and harmonize in terms of psychology's nuances before in the society, especially for the juvenile criminal justice system, peradilan anak ini, ya, diatur juga mengenai restorative justice. The restorative justice approach has been adopted through a system of diversion power. Kalau dalam peradilan anak itu bukan discretion power, tapi yang disebut dengan diversion power.
Sorry, Prof.
Yeah.
5 minutes left.
It is clearly that the Act number 11, year 2020, concerning juvenile criminal justice system, in the sense of diversion, is recognized as the transfer of settlement of child to who committed a crime in the process outside criminal justice system. The concept of diversion is principally based on the option that court always bring about the consequence, stigmatization, and future of the children. Legal values that right in handling criminal case employing restorative justice has been a frame of mind that seek mutual benefits in human interaction, namely win-win solution among the concerned parties. That is why restorative justice is an alternative resolution that attempt to obtain win-win solution agreement in certain criminal case settlement beyond the system of criminal justice, in order to have a realistic expectation and feel safe enough through a direct relationship and personal dialogue between concerned parties. I would like to conclude it. What can be concluded from my presentation? Law is principally cannot be separated from values of justice that to be achieved due to the essence of legal objective that prioritize to the purpose of justice or for the intention of legal certainty and utilization. It is therefore justice in harmony, and harmony in pace could be mentioned as the ultimate principle and moral foundation. That's all. Thank you.
Thank you so much, Pratama, for your presentation. A very delightful share about restorative justice. Before we move on to the question and answer, we have to hear the presentation from Dr. Hamonangan first, and then the next one is Dr. Mahbubul, and then the last but not least is Professor Andre Klim. So after all the presentation presented, as well, we continue to the question and answer all in one. So the next one is Dr. Hamonangan Albariansyah for the presentations. And before we start the presentation, we have to share the short CV from Dr. Hamonangan Albariansyah that Dr. Hamanangal Albariansyah will explore the comparative perspective on the restorative justice for safety crimes in the ASEAN context, and he will analyze the legal frameworks for workplace safety violations across various ASEAN countries. And the short CV from Mr. Dr. Hamanangal Albariansyah is he got his Bachelor of Law from Universitas Sriwijaya, also the Master of Law in Faculty of Law Universitas Sriwijaya. The latest is his Ph.D. he got from Universitas Indonesia Faculty of Law, and on behalf of Professor Dr. Topo Santoso S.H.M.H. and Dr. Eva Ahjani Zulfa S.H.M.H. To Dr. Hamanangan, the time is yours.
Okay, thank you. Assalamualaikum warahmatullahi wabarakatuh. Selamat siang menjelang sore untuk para mahasiswa yang masih setia di ruangan ini dan masih setia di jalur Zoom. Pertama saya ucapkan mohon maaf sebelumnya karena di sini ada guru-guru saya, ada para dosen yang juga sempat hadir di sini. Izinkan saya menyampaikan materi ini sebagaimana apa yang dimintakan oleh moderator. Izin kalau ada kesalahan, kekeliruan terhadap penyampaian materi khususnya pada dosen-dosen saya. Okay, let's see. I would like to give the material about the comparative perspective on restorative justice for the safety crime in the ASEAN context. Okay. Professor Nyoman already told about the restorative justice in philosophy, juridics, and the sociology, and then I would like to continue the some of the item about the restorative justice, but in the perspective of the comparative in the ASEAN context. Okay, let's see. Comparative criminal law is a field of study that examines and analyzes law and justice system across the different countries and the culture. It provides a broader understanding of legal principle, practice, and trend by the comparing them in a different context. The key area of the comparison is such as substantive criminal law, procedural criminal law, criminal justice system, and the cultural and social factor. There is a benefit for us, especially for the student and the researcher for us. A benefit for the comparative criminal law, first of all, is a policy development. By the studying the experience of the other countries, identification for the best practice, policymaker can learn from success practice and avoid the mistake. The second one is extended the understanding. It helps to understand the strengths, weakness, opportunity, and challenge of the different legal system. Promote international cooperation and action of the ideas, legal education for the legal scholar and student to broaden to the understanding of the law. At least there is a 6 comparative perspective on emerging issue today, and on this presentation I will explain some of the one of the emerging issue. First of all is cybercrime and digital privacy, and then the transnational organized crime, human rights and the criminal justice reform, environmental crime, criminalization of domestic and gender-based violence, artificial intelligence and autonomous weapon, criminalization on protest and freedom of speech, and then the last one is drug policy reform. One of the issue that I would like to take in this discussion is about the criminal justice reform in the ASEAN context, using restorative justice approach for the safety crime is the question mark. Safety crimes refers for a workplace violation of law, regulation, or standard related to workplace safety. There is an unsafety condition and unsafety act and health. whereas the failure of the comply leads to harm, injury, and death. Safety crime can include failure to provide adequate training or protective equipment, ignoring safety regulation or not implementing required safety measures, neglecting maintenance of equipment of infrastructure that pose a safety risk, allowing workers to operate hazardous conditions without proper safety guard, falsifying safety report or failing to report workplace accident. And then safety crime are pervasive issue that affect worker worksite. This violation can range from discrimination, harassment, unsafety condition, and wages. Safety crime using in the safety crime using RG, restorative justice or not. When we are using restorative justice for the safety crime, first of all is just punishing the next for the comparison. Next, and then next lagi. Next, terus, and this one. Okay, not using restorative justice for the safety crime, just punishing the offender. Offender have not accountability, not focus on restoring, repairing harm caused by the crime, potential harm in condition and action still existing in the workplace, labor community not encouraged in criminal process, mass publication reduce benefit in business process. If it is using restorative justice for the safety crime, first of all is a harm reduction, focus on repairing of the harm caused by crime, not just punishing the offender. Victim empowerment prioritize the need and experience the victim, giving them a voice in the process. Prevention, offender accountability, hold offender accountable for their mistake while providing for the rehabilitation and restoration. And then community involvement, encourage the labor community in the restorative process. And then the reduce cost, business good name. There is a benefit if it is the case the safety crime is used the restorative justice. And then how about the comparison in the ASEAN context? Next. At least first of all, Indonesian have a norm. Indonesian have a many norm about the safety, but for the main norm is the Undang-Undang Number 1 1970 concerning about the occupational safety law, and there is a Act Number 13 2003 about the manpower, and then some of the regulation about the electricity, and then shipping, and then some of the article in the KUHP about the concerning negligence causing death, disability, and injury. We have that some of the data. We have an accident in Indonesia, 2019 until 2021. We have up to 200,000 accident and the fatality among the 4,000, and then we have a great number for the accident and then for the fatality. And then what about the penalties? Penalties is a repressive justicial, fine, compensation, administrative penal law, and non-official in some cases doing compensation and circle mediation among victim and his family and the company out of the restorative justice framework. The challenge is a high rate, especially in the sector construction, mining, and processing. And then Malaysia have a norm about the occupational safety health 1994. It's called Akta Keselamatan dan Kesehatan Pekerjaan tahun 94, and then the Construction Industry Regulation, Factory and Machinery Act. Malaysian norm have a penalties about the for the offender. First of all, is a repressive judicial fine, imprisonment for the offender for negligence, compensation to victim, depending on the extent of the negligence. And then the second one is doing mediation and negotiation non-penal for light accident, non-fatality, improve relationship with the labor. And then in the Singapore is one of the state in ASEAN that have a role as a main practice on safety health, the best one in the Asia. In Singapore have Workplace Safety and Health 2006 Code of Practice on Safety and Health, Conduct, Risk and Assessment. Singapore norm have a penalties high fine up to 200,000 and more for the serious violation, imprisonment, prohibition from employment, company closure. Singapore have traditional focus on punishment as the primary deterrence, but in some cases large companies have chosen to resolve the issue by offering compensation to fixing and improving workplace safety mechanism, along with the company commitment to improve safety practice. Indicator for good healthy safety and environment in ASEAN, comprehensive regulation, law enforcement, and high safety awareness. And then next one is in Thailand. Thailand have a Labor Protection Act and Occupation 2011 have a sanction. The first of all is an administrative. The penalty administrative, such as a fine and suspension of operation business, temporary suspend until they are corrected safety violence, and then the penalty criminal, fine, imprisonment. However, in informal line, some case of work accident, victim of their family receive compensation negotiation through alternative mechanisms such as arbitration. The challenge is the same like Indonesia and Malaysia. Thailand have a high accident rate, especially in sector construction, agriculture, and manufacturing. And then the Philippines too. Philippines have a regulation, Labor Code of Philippines Occupational Safety and Health Standard. And then the Department of Labor Employment Order, Industry Specific Regulation. That norm, the content of the norm is a penalty, fine, suspension, and of operation, criminal prosecution. At the community level, same like the Indonesian and Malaysia, in social or informal settlement is possible through mediation and arbitration. The company compensates the victim and their family while restoring a social and emotional relationship with the parties involved by improving the work of environment. And then the last one is in Vietnam. Vietnam have a Labor Code of Vietnam, degree number 47 2022, and have a penalty, remedial, training, fines, suspension on operations, criminal prosecution, and informal direct compensation from the company to the affected worker. Still have a same have the same challenge for the ASEAN state too, high accident rate, especially in sector manufacturing, mining, and industry. And then the conclusion is for about the data is most of the ASEAN country for the context safety crime use the penalties, still use the retributive penalties, but in informal condition, especially in social, many use the mediation and arbitration about the compensation and restitution. In general, in ASEAN countries, the implementation of the formal settlement of occupational safety crime still use repressive approach, namely by the imposing fine and imprison on the perpetrator. No restorative justice approach was found in the criminal law. Singapore have a high standard HSA and law enforcement. Malaysia have comprehensive HSA regulation but not able to complete the challenge. Thailand upgrading comprehensive regulation HSA standard and the law. In Indonesia, Vietnam, and Philippines still development and updating of HSA regulation and have not yet resolved the challenge. The practice of informal settlement in ASEAN is actually closer to the principle of the restorative justice-based settlement, such as retraining, compensation, improving the work environment, eliminating red costs through the mediation, negotiation, or a type of the arbitration. I think that's all. Thank you very much. See you. Assalamualaikum warahmatullahi wabarakatuh.
Thank you so much, Dr. Hamdangan Albariansyah, for your very delightful presentation of the materials. The next speaker is Dr. Mahbubul Haq from University Sultan Zainal Abidin. Is he online on our Zoom operator? Can you help us for appear the picture of Dr. Mahbubul Haq from University Sultan Zainal Abidin, Malaysia? Thank you so much. Dr. Mahbub, is our voice here clear?
Yes, yes, his voice is very clear. Voice is very clear.
Thank you so much. Dr. Mahbubul Haq from University Sultan Zainal Abidin will provide a presentation on genocide, impunity and justice, the case of Rohingya Muslims in Myanmar. And his analysis will focus on the international legal responses and the ongoing struggles for justice in Myanmar. Before we move on to the presentation, I would like to share the short CV of Dr. Mahbub. Dr. Mahbubul Haq is currently working as faculty at the Faculty of Law and International Relations in University Sultan Zainal Abidin, Malaysia, of Bangladeshi origin. Dr. Mahbub conducted research and advocacy work for rights of non-citizens in Myanmar, Thailand, Malaysia, Bangladesh, and Indonesia. He obtained a Master's of Arts in History from Dhaka University, Bangladesh, and a Master's of Arts in Human Rights from Mahidol University, Thailand. Later on, in 2014, he obtained a Ph.D. in Human Rights and Peace Studies from the same institute in Thailand. He has published numerous research articles, books, chapters in internationally recognized publishers, academic journals, and Routledge published his book as co-author in this year. The title is The Rohingya Crisis, a Moral, Ethnographic and Policy Assessment, first edition on 2020. Published chapter in a book as main author, Right to Exist, the Rohingya and Their Struggles in Malaysia and Thailand. In the Displaced Rohingya, A Tale of a Vulnerable Community, Routledge, 2024. The Uzim Press published his book on 2019 on Rohingya survivors, regional security implication of gender-based violence. So, Dr. Mahbub, the time is yours.
Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Greetings from University Sultan Zainal Abidin, Penanggung, Malaysia. I'm asking, may I get assistance from organizer to open my slides, or I can show from here, I'm not sure. I already provided my PowerPoint presentations. Okay, thank you very much. Thank you very much. Yes, I have been working on the Rohingya issue last 19 years, not 20, 1 year, less than decades. Basically, I'm not a Rohingya, I'm a Bangladeshi origin, but I have been working on these issues inside of the Myanmar, outside of the Myanmar. As I'm basically students of human rights, so my paper discussions will be more focused on from the human rights point of view and criminal justice. So these topics of the students' discussions focus on the genocide, impunity and justice, the case of Rohingya Muslims in Myanmar. Before the cases, I would like to discuss from a little bit theoretical context. The legal scholars, legal practitioners and law students, you are very much familiar with the criminal law and criminal justice and how it is linked with your human rights. And the peoples at this moment, according to United Nations, most destitute people in the world in the Rohingyas, and how they are deprived from their seeking of justice from the national and international levels after the genocide. And still now they are facing genocide inside of the Myanmar. International criminal law drawn the public attentions and emerged as a working field for scholars and practitioners, and has no doubt that it has significant influence. Increasingly, international criminal law also faces various challenges. Right groups in Western countries strongly campaign the criminal accountability of individuals as an indispensable requirement for securing justice. Next slide. Contemporary international criminal law is now normalized the notion of anti-impunity. So my discussions was focus on the how the impunity culture developed and how we can minimize this impunity culture if we like to really seeking the justice for these destitute people inside of the Myanmar. The rise of anti-empathy framework and human rights make new debate which prioritize individualist civil and political rights. Restitutive justice focuses on assigning consequence to those individuals who have committed a crime. Next slide, please. Restorative justice, I think my previous three speakers already detailed discussed about the restorative justice. I don't want to make a more focus on the restorative justice. I think all of you, as especially the students of criminal laws, very much familiar about the systems of the restorative justice. It is focusing on repairing on harm done by the perpetrators and rebuilding that person's relationships with the victims and the society. While international criminal justice clearly originated as a response to human rights atrocities, gross violations of human rights, the motives underlying its emergence are the subject of much debate among the scholars and practitioners. One of the important trends in criminal justice is a shift towards rehabilitations. Earlier, the entire justice systems broadly focused on the punishment and retributions. Less attention on helping offenders to address the root cause of violence or post-conflict societies. How the criminal justice and human rights link together, it is convergence or confrontation or confront from the theoretical point of view and practically what actually we found in. From 1990s, rights groups campaigning globally. I don't want to think that it's a right group is only for the Westerners. Apart from Westerners, Asian countries also, there are some voice raises the individuals, criminals' accountability as an indispensable requirement for the seeking of justice. There are various national tribunals conducted, international criminal courts and tribunals emphasize the idea of anti-impunity with the links of the vocabulary of international criminal law, in particular, becoming dominant frame of articulating injustice. Next slide. International criminal justice and their close connections to the development of international human rights protections. And international criminal justice emerged as a response to the novel and genuine concerns of the safety of humanity. Or is it the manifestations of the global governance, priorities to the post-conflict societies or post-conflict scenarios? Scholars argues that International Criminal Tribunal, ICTRI, the ICC cannot that themselves represent international criminal justice. They have a lot of limitations, barrier. Yes, and these mechanisms we cannot say that yes, this is the proper and really people can get or seeking the justice. With these limitations, I would like to focus what happened, the cases of the Rohingya Muslims, especially after genocide and before genocide, and where is their justice? Is really justice working for them? Because genociders are still in the power, and those who are fighting for the democracy in Myanmar, once they also defending the genociders. So these situations I would like to explore more. I know I have to complete within the time framework, so it is not possible for me to detail discuss. Just looking little bit historical situations of the Rohingya Muslims in Myanmar. Rohingyas are ethnic linguistic minorities groups who have been living in the present Rakhine state, which is part of the present Myanmar nation states, as a people of indigenous, but due to their different ethnic religious identity, these Rohingya people became unwanted in Myanmar. Now, the status of the Rohingya has no problems before 1982 citizenship law. Very ridiculous. Rohingya became citizens, lost the citizen's identity, but until 2010 to 15 parliament, 2010 to 15, the Rohingya representatives was in parliament. But the Rohingya as a group became stateless through the 1982 citizenship law, or I would like to say not stateless, rather than lost their citizenship status. And this citizenship law is very much controversial and not meet any international standards. And it is now proven that this citizenship law prepared and introduced just to exclude the Rohingya Muslims minority. Early 1980s rights groups criticized the Myanmar government policy and exclusion against the Rohingyas. Situation has been changed after 2012 communal riot, and many places, not only the Rohingya, other Muslims also face difficulties. Their properties attacked. Other ethnic Muslim groups also killed by the Buddhist nationalists. And it was state-sponsored violence against not only the Muslims, not only the Buddhists, not only the Rohingya and other Muslims. We know in this year, 25th August 2024, it was the 7th year of the Rohingya genocide. Myanmar's military what conducted it. The genocide had consisted of two phases of deed. The first was military crackdown that occurred October 2016 to January 2017. And the second phase, it was conducted around August 2027. Consequently, more than 1 million of Rohingya have fled the country because of well-founded fear of persecutions. Now, currently at this moment, 1.2 million people are Rohingya as displaced people or refugees living in Bangladesh, and other, especially some are coming in Indonesia, but it's not too much. And next to Bangladesh, maybe Malaysia is one of the destinations for the Rohingyas. Next slide, the genocide and the Rohingya. September 2018, the UN Human Rights Council mandated independent international facts-finding missions on Myanmar, released a sharing report detailed state violence about the Rohingya, demanding that Myanmar's military leadership be held accountable for genocide. Reports also concluded that the military, as well as some civilians, have committed genocide, crime against humanity, and war crimes against its own people. Then 11 November 2019, the Republic of Gambia, with the backing supports from the 57 nations in the OIC, filed a case before the International Court of Justice, alleging that Myanmar atrocities against the Rohingya in Rakhine State violate various provisions of the Conventions on the Prevention and Punishments of the Crime of Genocide. Myanmar raised a number of preliminary objections about these applications, about the jurisdictions of the court and admissibility of the applications. From the Myanmar side, it's claimed that the real applications in the proceedings was not Gambia, it was in OIC, when OIC is a nation, not states, and they cannot be proceed these cases. Therefore, it should be disqualified from making applications to the International Court of Justice. But after 2 years, okay, this is very interesting information. On that time, icon of democracy, State Councillor of Myanmar, Aung San Suu Kyi, went to International Court of Justice to defend the genociders. And we know after a few months what happened for her, and still now she is in the jail and arrested, and now whole country captured by the Myanmar military. On July 2022, the court rejected objections raised by the Myanmar. However, the ongoing legal procedures might take 1 decade, and we know justice delayed is justice denied. We have one examples in the context of ASEAN. What happened 1975 to 1979 genocide in Cambodia. And after this genocide, where 2 leaders of the genocide, Pol Pot's Khmer Rouge regime, both 90 years old, have been convicted of the genocide almost 50 years after the genocide of Cham Muslims community and the Vietnamese in Cambodia. So they died. Actually, both are naturally died because by this time, the process started 1975 to 1979, and it takes 40 to 50 years to come on the final decisions. Okay, I would like to move on the inside of the Myanmar. What is happening at this moment? After nearly 4 years of the military coup in Myanmar, the landscape of the country's conflict has been changed. The military faces a national uprising that spans the breadth of the country. It is the first time of its Myanmar history, because Myanmar history 1962 until now, except few years, the whole country ruled by the military. And military at this first time has lost the control most of the countries and significant places, significant bases, military bases. The Human Rights Watch and various media published news that currently Myanmar military and the opposition Arakan Army, the Buddhist Rakhine militant groups, have committed extrajudicial killings, widespread arson against the Rohingya, Rakhine and other civilians since end of the 2023. Next slide, please. UN Human Rights Chief Volker Turk stated that attacks on civilian flaming Rakhine and fears repeated the history of 2017, what happened in the genocide and atrocity against the Rohingya. Still now, there are phenomena is going on. Over the past 4 months, tens of thousands of people, many of whom are Rohingya, have fled. A major offensive by the Arakan army to take control of the border areas, because Rakhine State is the western border of Myanmar between Bangladesh and Burma, Bangladesh and Myanmar. As the border areas crossing to Bangladesh remain closed, and Bangladesh foreign advisor says that they will not bear or accept single Rohingya. But the reality is around 10,000 new Rohingya entered in Bangladesh. So next slide. According to Human Rights Office, both the military and Arakan army control most of the townships in the Rakhine states, have committed serious human rights violations, extrajudicial killing, some involving beheading, abducations, forced recruitment, indiscriminate bombardments of town and village, using drones and artillery and arrows and attacks. So military's unlawful recruitments of Rohingya men and boy has stopped communal tensions between the Buddhists and Muslims again. Such attacks stand in sharp contrast to the obligation of all parties under the international humanitarian law. That is not my discussion's agenda. Just I would like to make sure that what actually happened and how it is also violation of other international rules and regulations. And the provisional measures, what urged from the International Court of Justice to protect the Rohingya against risk for further harm. It was coming from the International Court of Justice, but it is not worked out in the context of Myanmar. In these situations, right now, what I am saying that Medicines Sans Frontiers warns of urgent need to protect the civilian caught of escalating conflict in Western Rakhine states. Currently, community leaders, Rohingya leaders inside and outside of the countries. I had contact with them and often conversations online and sometimes face-to-face meeting. Some 200,000 Rohingya are internally displaced, and these internal IDPs, after 2012 communal riots, are in dire situations. Additionally, 11,000 members of the community, about half of them are children, are trapped nearby Rakhine capital state Situi, surrounded by landmines, unable to flee as the fighting age close to the city. So this is the situations of the Rohingya after preliminary measures introduced by the International Court of Justice and international communities rules and some mechanisms. So concluding remarks, I would like to say, UN Human Rights Chief, the previous chiefs, not the present chiefs, advised to the Rohingya community last 2-3 years before I saw some other documents, and it was sometimes highlighted in the media that please be patient, don't need to go inside of the Myanmar, you can stay as a refugee in other countries, and it is not suitable time to go inside of the Myanmar. However, without a permanent peaceful solution of this problem, Myanmar will remain divided and unstable in the years to come. Today, the genocide survivors inside Myanmar and forced displaced Rohingya in Bangladesh, Thailand, Malaysia are living without a future and dignity. Since November 2019, different initiatives have been taken against the genocide in Myanmar, including provisional measures by the International Court of Justice, what we found the case Gambia versus Myanmar. Despite these measures, community leaders, rights groups witnessed that the Myanmar military has continued to burn the Rohingya villages, mass graves in order to destroy the evidence of atrocities committed. What they committed atrocity, the genocide. And still now it is going on. The ongoing situation in Myanmar suggested that without accountability and justice, the future generation of Rohingya will face similar situation in the present generations. It means we have a lot of mechanisms, we have a lot of initiatives to stop the genocide, but the reality said they are still in the genocide and no international protections and national protections work out to protect the Rohingya inside Myanmar. Thank you very much to give me an opportunity to share my experience from the Rohingya peoples. Those are most destitute people in the world. Terima kasih.
Thank you so much, Dr. Mahbub, for your delightful presentation of your materials. So, we begin to the next session. I would like to ask if our last but not least speaker, Professor Andre Klip from Maastricht University, is online with us. So, Professor.
Yes, I'm here. Good morning.
Good morning. Good morning.
Good morning, Prof.
Netherlands, Prof. So, in Indonesia, we are in 2 p.m. already. So good morning to Professor Andre Klip. Operator, please help us to appear Professor Andre in our Zoom right now. So, okay. Thank you so much, Prof. Andre. Good morning, Prof. So everyone, Professor Andre Klip is not only a distinguished expert in criminal law, but also served as the promoter of one of our own lecturers, Zulhidayatullah, in Maastricht University. And we are very honored to have him with us, and I look forward to his insights on the emerging issues in criminal law. So, before we move on to the presentation, I would like to share the short CV from Professor Andre Klip. Professor Andre Klip is Professor of Criminal Law, Criminal Procedure, and the Transnational Aspects of Criminal Law at Maastricht University. He is a member of the Royal Netherlands Academy of Arts and Science. He is Vice President of the International Association of Penal Law and directs its scientific committee. He has supervised many Ph.D. students and is always interested in new challenging research proposals. He is also founder and editor of the annotated leading cases of international criminal tribunals. He is the author of European Criminal Law and Integrative Approaches and co-author of Comparative Perspectives of Criminal Procedure. He is also the editor of the European Journal of Crime, Criminal Law, and Criminal Justice. And throughout his career, Professor Andre Klip has been frequently involved in national and international legal practice. Both as an academic and as a practitioner, he is very much engaged in international cooperation. He has been invited as a guest lecturer, researcher across the globe. Within the Maastricht Institute for Criminal Science, he participates in an interdisciplinary research group which is frequently invited to conduct studies on crime, perpetrators, and how to combat criminal behavior. He is a judge at the Hertogenbosch Court of Appeal or Criminal Division in the Netherlands. So, the time is yours for Professor Andre Klip.
Thank you so much for your kind words of introduction. Rektor Universitas Sriwijaya, para pimpinan dan dosen Fakultas Hukum Universitas Sriwijaya yang saya hormati, dan juga para hadirin sekalian yang saya cintai.
Thank you so much, Prof. Please give
so
Professor
much,
Andre Klip applause. So here we have our Dean, Professor Dr. Joni Emirzon with us on Zoom.
Hello, Prof. Andre. Thanks, Prof. Andre.
Yeah. Thank you. It's a pleasure.
Yeah.
Shall I continue?
Oh, please, continue.
Yeah. Pada momen kali ini, saya ingin mengucapkan secara khusus dan langsung kari Belanda. Selamat atas ulang tahun kepada Fakultas Hukum Universitas Sriwijaya yang ke-64. Suatu kehormatan bagi saya dapat berbicara pada momen yang bersejarah ini. Saya sangat berterima kasih kepada panitia penyelenggara di Fakultas Hukum Universitas Sriwijaya atas undangannya. Saya juga sangat senang menjadi pembimbing doktoral Zulhidayatullah Nur di Universitas Maastricht yang sekarang juga adalah dosen di Universitas Sriwijaya. Izinkan saya memberikan pantun untuk Fakultas Hukum.
Oh, asik.
Kalau pergi ke kebun, jangan lupa memetik pepaya dengan umur yang ke-64 tahun.
Okay.
Fakultas Hukum Universitas Sriwijaya semakin berjaya.
Thank you so much, Prof.
Thanks so much, Prof.
Pada presentasi kali ini, mohon izinkan saya untuk menyampaikan pidato ini dalam bahasa Inggris. Terima kasih atas perhatiannya.
Thank you so much, Prof. Andre.
Thank you so much,
So before we
Prof.
start the presentation, we would like to please our Dean, Professor Dr. Joni Emirzon, to greet you in our seminar. To Professor Dr. Joni Emirzon, the time is yours, Prof.
Hello, Prof. Prof. Andre Klip. How are you, Prof? I am very glad to meet you in this room. Welcome to Palembang by Zoom. We are glad to meet you, and then it is time for us to many knowledge from you. And then Mas Nur is our lecturer. I think thanks. So many material you give me about what is information about global here, global today, yeah, about criminal. Yeah. Thanks so much, Prof. Yeah. 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 Almira.
Okay, thank you, Prof. Later we will meet Prof. Andre Klip whether in Indonesia or in Netherlands. Yeah, Prof. Joni with Mas Nur also.
Yeah.
Yeah. So we will start the presentation from Prof. Andre Klip. After the presentation from Professor Andre Klip, we will begin the question and answer for all of the speakers from Professor Dr. Inyoman Nurjaya, Dr. Hamonangan, and Dr. Mahbub. Also, last but not least, with Professor Andre Klip. So, Professor Andre Klip, the time is yours.
Yeah, thank you so much. Thank you. Ladies and gentlemen, I'd like to speak about the jurisdictional rules in the penal code of Indonesia. And of course, we need to go back to the origins. And next slide, please. If you look at the previous penal code, of course, you have to go back to this old code, the penal code for the Dutch East Indies, which was a literal copy of the Dutch penal code of 1886. And you see that in those provisions, the Dutch original are definitely there. They are classical jurisdictional principles. So, like all states in the world, the penal code of Indonesia is applicable on its territory, which you find in Article 2. Article 3 deals with the ships that derive from the Dutch East Indies. And Article 4 is a protective principle. I found the principle that you see in Article 5 a very interesting provision, because that's a kind of colonial active domicile principle. To a certain extent, it is a rule of recognition of jurisdiction over those that live in Indonesia, those that are domiciled in Indonesia. In the Dutch version, in Europe, it is active personality. It relates to nationals. But in the colonial period, the Dutch did not want to recognize the Indonesians as nationals. So they created the domicile principle. It is in essence a recognition of the existence of apartheid rules in the colonial period. Article 6 relates to the question that if you have jurisdiction over offenses that take place out of your territory, you must apply a double criminality rule. So there must be also a criminalization elsewhere. In other words, you may apply your own national law on offenses that took place out of the country, but only if the local law also says this is a criminal offense. The other principles, 7 and 8, are also quite common and still in existence today. If you look at and the next slide, please. If you look at the developments in the Netherlands, please the next slide. Then please. You see that in 1886 we had the similar rules. I said already the rules applicable in Indonesia up to recently were copy-paste from the Dutch rules. The Netherlands took some changes, but it waited quite long. Up to the 1970s, there was no change at all. And in addition to that, despite the fact that there was jurisdiction over crimes committed elsewhere, for instance, on the basis of active personality, there was hardly any application. So the Netherlands could prosecute nationals who committed out of the country offenses, but they hardly ever did so. that changed in the period between the 1970s and the 2000s. And there we see what I call a reluctant expansion. So the Netherlands did extend, it did create more possibilities, and that basically was a result of treaties concluded under the umbrella of the United Nations. For instance, treaties on combating hijacking, treaties on combating torture, treaties on combating the attacks on diplomats. And for instance, the United Nations Drug Convention of 1988. And that led to situations that when such crimes occur, for instance, the hijacking of a civilian airline, that the Netherlands would have the potential, the power, the competence to prosecute those individuals. And one of those conventions was, for instance, the Montreal Convention, protecting the safety of civil aviation. And that is a convention that criminalizes that bombing of airplanes, civilian airplanes, take place. In this period, we also see that there are some voices in Parliament that say the Netherlands should do more. Not only legislation on paper, but it should actually apply that legislation, and it should use that legislation and go after crime committed elsewhere in the world. And this was a development that was accompanied by the view of the government that The Hague should be the legal capital of the world. And you are well aware that the International Court of Justice is in The Hague, but especially in the 90s, the Netherlands was also very recipient and very open to receiving the International Criminal Tribunal for the former Yugoslavia, the Appeals Chamber for the Court for Rwanda, the Appeals Chamber for the Sierra Leone Court, and finally the International Criminal Court. There was a very clear claim for the Netherlands as a small country to have The Hague as the legal capital of the world. Well, if you have such a claim and such an ambition, you must also do something. And that is what Parliament forced, and Parliament also was able to implement. So after the 2000s, we see what I call an unlimited expansion. Unlimited in the sense that where in the past the government was rather reluctant, saying we should not have a too extensive application, the Dutch should not interfere in cases that happen at the other end of the world. But since the 2000s, the political view was wherever serious crimes occur, the Netherlands should have jurisdiction. I had the honor to prepare a report, a legal opinion on the revision of the first paragraphs of the Penal Code that had not changed since 1886. And to a large extent the government followed my advice. And it also introduced the principle of passive nationality, meaning that wherever a Dutch national is the victim of a crime in the world, the Netherlands have the competence to prosecute. And the government has always said, we don't want this because that creates too many situations where the possibilities to prosecute are very, very difficult. If I become a victim of a crime in Indonesia, the Dutch authorities have no knowledge of what happened there and do depend on the local authorities. So the view was always, you better have it with the local authorities. But that view was abandoned. And now we have passive nationality, we have a far more broader application of the principle of universality, meaning that there does not need to be a relation at all with the crime. Universality is reserved for the most serious crimes, such as genocide, crimes against humanity, war crimes, but also applies to the crime of torture, for instance. So regardless of the link that the Netherlands may have, there is a potential to prosecute. And it was applied. Since the 2000s, we see many cases before Dutch courts relating to crimes that were committed, for instance, in Afghanistan, in the Congo, in Uganda, in the former Yugoslavia, and other places of the world where there's no relation with Dutch nationals, no relation with any Dutch interest, but simply it relates to crimes that occurred there and are of a very serious nature. The initiative often was caused by the fact that there were refugees from those countries, especially in the case of former Yugoslavia and Rwanda. We had quite some refugees from those countries, and among the refugees there's not only victims, but there's also a group of perpetrators, and the Netherlands targeted those individuals. The other group that was targeted were Dutch businessmen that were involved in crimes elsewhere in the world, and especially Dutch businessmen that earned a lot of money. For instance, Mr. van Anraat, who assisted Saddam Hussein of Iraq in producing chemical weapons that he used to exterminate a Kurdish population in northern Iraq. And also a Dutch businessman, Kouwenhoven, who supplied Charles Taylor of Liberia with weapons that enabled him to kill many people in Liberia. So there is a clear message from the Dutch government that we don't want people who commit crimes elsewhere in the world to seek refuge here in the country. The change was also enabled by the fact that the Dutch authorities created a unit, both with the police, as with the prosecution, as with the court, that only deals with international crimes. So, and it is definitely, it is the key to any potential prosecution, that if you don't create a unit's specialization, then the law on paper will never be implemented. On the 1st of July 2014, and I recall the date because it's a very important date, the 1st of July 2014, the new rules on extraterritorial jurisdiction entered into force. And I explained already the changes that it took about. If we then compare this to the new Indonesian rules, and I'd like to see the next slide, please. The new Indonesian rules with the penal code of 2023. I understand that the legislation still needs to enter into force, but the act is already there. We see, to a certain extent, a continuation of the previous penal code that was adopted in the colonial time. It is, as a first impression, it remains modest in the sense that it's not very expensive in creating jurisdiction outside the Indonesian territory. But it is also, it flags that it is a modern code. And I'll explain that to you why I think it is a modern code and why it was also timely to create the code. In Article 4, you see a modern variation of the territorial principle in combination with jurisdiction over Indonesian ships and airplanes. And the extension very much is in paragraph C of Article 4, where you see that there is an extension when the consequences of the crimes are felt on Indonesian territory. That is, of course, a logical thing, which means that the perpetrator could be out of the country, But still, for instance, by making use of telecommunication, create results within the Republic, then you should fall under its jurisdiction. These are also rules of jurisdiction that are perfectly acceptable under international law. The same goes for the principles that are found under the heading of the protective principle, protection of all sorts of Indonesian interests that may be affected abroad. So it could be an attack on the national security, the dignity of the president. If your new, I congratulate you with your new president. If your new president travels abroad and a crime would be committed against him, of course there is an interest of Indonesia to respond through its own criminal law to those offences. The most expensive and the most interesting jurisdictional basis is in the last paragraph, where the passive nationality is recognized. We have the modern version, no longer the colonial version. It is the modern version based on nationality that Indonesian citizens are protected. And here you have chosen, Indonesia has chosen for a very safe formulation, the Indonesian citizen in accordance with an international agreement with the state where the crime is being committed. So if there is an international treaty, and Indonesia is also a party to quite a number of treaties that combat international crimes, then the Indonesian citizen is protected by the tool of the Indonesian Penal Code. Article 6 is the most expensive for Indonesia, and that is the universal jurisdiction, meaning that Indonesia has the power now to combat those very serious offences. There is a legitimization under international law. There is a link in the principle, in the code, with treaties. So that also means that here there's a clear choice to, or a clear indication that Indonesia does not want to create jurisdiction on a basis that is doubtful under international law. There's always the justification and legitimization of the jurisdictional basis on international law, and I think that is a safe way to go. I think the most one of the more innovative paragraphs is Article 7, where Indonesia has accepted the transfer of proceedings. And this means that you can, if you don't have jurisdiction, you can accept the jurisdiction that another state has. And this is, I would say, a modern, very modern, creative, innovative provision. And I can give you an example of that, relating to also an international crime that is known, I think, also in Indonesia. On the 17th of July 2014, Malaysia Airlines flight MH17 departed from Amsterdam, going to Kuala Lumpur. And the plane was downed over Donetsk, Ukraine. And now we may all know where Donetsk is and where eastern Ukraine is. But this was a plane, a civilian airplane, that was downed by a Buk missile. All passengers, all 298 passengers of the civilian plane and crew died. The large majority, 198, was Dutch nationals. There were 12 Indonesian nationals. This crime occurred over Ukrainian territory. So who has jurisdiction? But it's clear that if it is over Ukrainian territory, Ukraine has a jurisdiction. Does the Netherlands have jurisdiction? Well, the plane was Malaysian. The nationals were predominantly Dutch, but not all. But here we see that this event took place after the 1st of July. The new Dutch legislation creating passive nationality had just entered into force 70 days before. So it meant that the Netherlands had jurisdiction over 198 victims, but not overall. And that was a problem. The Netherlands wanted to prosecute the crime, and there was a joint investigation into all the elements of the crime. In the end, Ukraine and the Netherlands concluded the treaty on the transfer of proceedings from Ukraine to the Netherlands. So the Ukraine, a state with full jurisdiction over the crime, transferred this full jurisdiction to the Netherlands. And this is what I think is a perfect example of where the need for a transfer of proceedings may be. So there may be a country that does not have jurisdiction over the whole country, but in the end has more interest in prosecuting the crime than the full jurisdiction. And this is what happened. The crimes, the perpetrators were prosecuted. All 4 of them, 3 Russians and a Ukrainian national, were tried in absentia. 3 of them were convicted to life imprisonment and 1 was acquitted. I don't know whether Indonesia has already concluded treaties of this kind, but these are the ways, the cases, the kind of cases that may lead to it. Article 8 is a very classical principle of active personality, meaning that Indonesian officials, Indonesian nationals, must obey Indonesian law wherever they go. I often say to my students, as a national, your penal code always goes with you. And that is applicable to Indonesians as well. You must obey your penal code, and you cannot commit a crime that is in the penal code. Of course, there is a relation to the local crime, so the local law. So there is a demand of double criminality. Also, this is a very classical example of jurisdiction over your nationals. Now, Article 9 states the limits under international law. For instance, even if you have jurisdiction, you will not prosecute an ambassador in Jakarta that comes from another state, because there's an immunity for ambassadors that come to your country. You will not prosecute a head of state of another country, because international law stipulates that there is a rule against it. Having said that, I think it is good to look at least the next slide to compare the differences that exist between the Indonesian legislation and the Netherlands. And both legislations are very, very recent. That is interesting because if you look internationally, most legislation on jurisdiction, on application of the penal code is very, very stable. But so both our countries have recently amended that. The differences between the Netherlands and Indonesia are very limited. There are some differences, but they're not differences of principle, which I would say to a certain extent is logical, because the origins are the same. The structure has remained the same. The understanding of jurisdictional principles and the link with the crimes in the special part remains the same. But there are some differences, especially when it comes to the fact that the Netherlands definitely has a more extensive jurisdictional view. The explanations are very simple, very clear. One is the impact of the European Union legislation on the Netherlands. That is a development that Indonesia does not have. EU legislation very often criminalizes certain conduct, but adds a jurisdictional paragraph to it. So we have, for instance, a EU directive on child pornography, a EU directive on corruption, a EU directive on organized crime, and all these directives add a paragraph: please create jurisdiction when the crime occurs out of the country. So that forces the Netherlands to be more expensive. I think the other explanation is for the Netherlands being more expensive is the geographical position and the economic position in Europe. We are a small country surrounded by many other states within Europe. Indonesia is a big country where the distances are far more bigger than in the Netherlands. We have lots of foreigners from the EU that can travel freely throughout the European Union, and as a result of that, people do not only work and pay taxes, but there is a small minority that may also be involved in crime, either as a perpetrator or is the unlucky victim of a crime. That is a consequence that leads to us having jurisdiction over all these kinds of offenses. And the last element I'd like to mention is the status of international criminal tribunals. I mentioned this, the Netherlands is the host state of most of the international criminal tribunals, including the International Criminal Court, and that has a side effect in the sense that the Netherlands also wants to be active itself, not only by hosting those international criminal courts, but also by prosecuting international crimes itself. Yeah, do we still share the same concept of jurisdiction? I would say yes, very clearly. The construction is the same. There are technical little varieties, but the construction remains the same. I would say the Indonesia is more careful in connecting to the boundaries of international law. The Netherlands does not explicitly express that. And Indonesia does so, not only in Article 9, but also in other paragraphs of the Penal Code. This is expressed. So that shows respect for international law, and that is I would say, a good thing. Then to conclude, a few thoughts for the future, because despite the fact that please the next slide, the last slide. Despite the fact that we have some differences, despite the fact that certainly expansion took place, we must also see that the more power, the more competence you have over crimes committed out of the country, the more crimes there will be on which you will not act. And it is simply because the crimes occur at the other end of the world, and you cannot send your police to collect evidence. And this is a serious issue, but it is also explained that most extraterritorial jurisdiction is not used. Even when it concerns international crimes such as genocide, crimes against humanity and war crimes, most extraterritorial jurisdiction is not used. For the very simple reason that you are not positioned to collect evidence easily. Here is the problem, also with international law. International law does accept that states like Indonesia, like the Netherlands and other states, extend their jurisdiction over offenses occurred elsewhere. But international law does not allow to send your police to those states. And here is what I call the extensive jurisdiction on substantive criminal law and a very limited power to do something with it on the location. Because if we want to investigate a crime that occurred at another place of the world, will still depend on the local authorities to assist. And that, on the one hand, is problematic. On the other hand, is logical, because you don't want foreign police on your territory. But it also creates a problem for the investigation. So it's some. Looking at the new legislation of Indonesia on jurisdiction, I would say I can congratulate you with the modernization. I think it is a legislation that corresponds to what other states have done when modernizing, and it is a safe basis for prosecution in those situations that you want to do that, and it is also a legislation that for sure finds its justification under international law. I thank you very much for your attention.
Thank you so much, Prof. Andreklev, for your very insightful presentation. Now that our presentation have concluded, we will begin the final question and answer session for Professor Dr. Inyoman Nurjaya, Dr. Hamonangan, Dr. Mahbubul Haq, and Professor Andreklev. To our in-person audience, please raise your hand to ask your question, and to our online participants, you may type your questions in the Zoom chat and I will direct them to relevant speaker. So please, to our audience, the first one is the one in front of the second one, right there, the third one, and the next one I guess from the online Zoom. Next. So please, the time is yours.
Ini jam berapa? Selamat sore. Good afternoon. My name is Mona Evita. I'm from Faculty of Law, Universitas Sriwijaya. And my question to Bapak Nyoman, salam kenal Bapak. I wanna hear about your opinion about restorative justice. As your presentation, how about restorative justice if be implemented to extraordinary crime like corruption or human trafficking, terrorism too? Because I direct to Prof. Eva from Indonesia University. She believed to can be implemented restorative justice to terrorism case. So Pak Nyoman, I wanted to hear about your opinion because direct to paradigm of restorative justice in minor offenses to serious crime. Thank you, Pak Nyoman.
Okay, so kita langsung jawab Pak, atau mau di Okay, so we move to the next question first. After that, we will answer the question one by one from our speakers. The next one.
Test. Okay, again, thank you very much. This question is for every speaker, and because I want to hear every thought, every single mind in the criminal justice. So this question is about, oh yeah, I forgot, I'm sorry. But I really want to hear the opinion from Mr. Mahbubul Haq because it's his speciality. Okay, the question is about genocide. The question is about genocide and how do we solve that genocide? Because in this current situation, I think it's just not enough. Yes, we have ICG, we have ICC, International Court of International Criminal Tribunal, but it's just not enough because the genocide, like we all know, happens in Israel and Palestine. Is one of the most outrageous things that have happened to the human rights. So I want to ask every single speaker, how do you think we solve this question? How do we solve, as a combined mind countries represented by the League of Nations, do we solve this criminal acts against humanity? That's it. And I really want to know what Mr. Mahbubul Haq think about this. Thank you very much.
Thank you, Farid, for the question. Another one is from the one in front of with the black suit.
Good afternoon, Professor. I want to ask for Professor Inyoman. So I had a discussion with a student professor from Brawijaya University from ALSA LCUB. So recently, case of major crime committed by children, like in Palembang, children under the age of 18 commit murder and rape. So have become frequent. My question to restorative justice is, can RG be applied to children who commit major crime, such as murder and rape, or is it more effective to apply adult law without saying the subjectivity of the essence of child himself? Thank you, Professor.
Thank you so much, Jusniar, for your question. The next one, we move to the online by Zoom chat. Maybe there are some questions. Operator, can you help me with the question? So the participant on virtual is raising the hand, or I have to share the question by the chat, from the chat? Okay, let's move to answer the question from the participant on the venue first. The first one is from Mona Ervita to, I guess, to all the speakers. We have to let all the speakers but begin with Prof. Nyoman Nurjaya about RJ for terrorism, right? So we start from Professor Dr. Nyoman Nurjaya. The time is yours, Prof.
Thank you. It is a critical time, yeah? A bit sleepy. Well, when we are talking about the restorative justice paradigm, especially in criminal justice system, it is close relation with what the so-called this retributive justice in criminal law. That's why there is an history connection between restorative justice and retributive justice. In criminal law, we do understand that the essence and characteristics of the criminal law, what the so-called lex talionis, that is the law that create to the only giving a punishment, giving the penal sanctions to make it the people who committed the crime in society to have justice given by the state, because the state have a right to punish the people who committed the crime. That is in criminal law. We do understand about jus in Latin, jus punale and jus puniendi. Nah, in the development of criminal law, especially in criminal justice system, there is a development thoughts about on how to replace retributive justice to restorative justice. It means that there should be another option in settling criminal case in society, that it is included in law enforcement, criminal law enforcement system through the criminal justice system. Restorative justice is a justice given by the state, to handling the criminal case beyond the system. How to make it? By inviting the victims and the perpetrators or criminals to discuss and make an agreement to finish the case consists of peace and justice and obtain the best solution. The best solution in criminal case for the best interest for the victims. If the criminal case settled by the system, you know that the rights of the victim is ignored, diabaikan. Because the criminal procedure law, the only regulating the rights of the offenders. The rights of the victims is all not for the all criminal case. Restorative justice can be employed only for the selected, the minor felony, kejahatan ringan, and the misdemeanor, itu pelanggaran-pelanggaran lebih bersifat administratif. Jadi that is why in detailed regulation enacted by the police regulation, prosecutor regulation, and the judicial regulation describing the Act number 8, year 1981, and the Act for the police, prosecutor, and tribunals defines a condition, mengatur tentang persyaratan, where what the criminal case can be settled by restorative justice or not. That is a certain condition to using the restorative justice in handling criminal case within the criminal justice system. Itu aja. Ada persyaratannya, tidak boleh semua. Kalau menyangkut nyawa, wah, menyangkut kerugian negara, wah, apalagi residivis juga nggak bisa. ya, non-recidivis. Itu ada syarat-syaratnya yang dimaksud tadi. Ya, kita bisa baca di aturan masing-masing itu. Ya, nah, for the second one, children criminal case, the enactment of Act number 12, 2011, concerning the children criminal justice system. Yeah. The legal foundation to using restorative justice, especially in children criminal case, that is the so-called diversion power. Diversion power, the only use for the children criminal case. There is a condition on how restorative justice based on diversion power that can be used by the law enforcement officer. There is a number of conditions too. Not all children criminal case can be divine by the restorative justice. Jadi hanya memang ada persyaratan, tidak semua kriminal pidana anak bisa diselesaikan dengan criminal justice. Ada pertimbangan dan itu diatur ketika sudah di pengadilan ya. Undang-Undang Nomor 48 Tahun 2009 tentang kekuasaan kehakiman, kemudian ada Peraturan Mahkamah Agung Nomor 1 Tahun 2021 itu. Ada persyaratannya, tidak semua bisa. Itu intinya, the essence of criminal justice, the essence of restorative justice. Ya, that is another option. In a criminal justice system to obtain the best solution. For whom? For the interest of victims. Yeah? Mainly for the victim and the offender. The philosophies of restorative justice is mainly on how to restore the condition, the situation in society as before. In Latin, I define the terms on how to mention restorative justice is a method or approach to settle a criminal case is mainly to restore, mengembalikan, memulihkan seperti dalam keadaan semula, the condition in society as before. Istilah Latinnya ada itu, ternyata saya temukan. Restitutio in integrum. Itu filosofinya, filosofi dari restoratif justice. Ya, restitutio. Apa? Mengembalikan seperti dalam keadaan semula. Karena terjadinya kejahatan itu membuat kekacauan, keresahan, kecemasan, ya, rasa mencekam dalam masyarakat. Sekarang dengan mendamaikan, tidak melalui sistem peradilan pidana yang prosedural dan belum tentu bisa mencapai apa yang disebut dengan substantial justice. Itu hanya procedural justice. Tujuannya hanya itu. That's all. Thank you.
Thank you so much, Professor Dr. Nyoman Nurjaya, for your answer. So we move to, because the question is more about the restorative justice, we please to Dr. Hamanangan to adjust the answer for the question about the restorative justice, terrorism for restorative justice, and restorative justice to children underage. So for the participant in online, that's okay if we begin this question and answer with English or in Bahasa Indonesia, because we have the auto transcription in our Zoom. So to our speakers, it's also fine if we answer the question by English or in Bahasa Indonesia. Please, yeah.
Okay, I will answer with Indonesian language supaya nggak jadi multitafsir itu ya. Tadi pertanyaannya tadi dari Mona mengenai apakah untuk kejahatan extraordinary crime itu dimungkinkan untuk RJ. Ini pendapat personal itu ya. Kalau kita lihat dari sifat extraordinary crime, itu berarti itu tindak pidana. Sifat perbuatannya itu kesengajaan. Ada kesengajaan, ada perencanaan, dan dalam perspektif saya itu adalah selama tindak pidana atau perilaku itu dilakukan secara sengaja, berarti tingkat ketercelaannya itu akan sangat lebih besar. Untuk tingkat ketercelaan yang lebih besar itu, pendapat pribadi saya itu tidak boleh di-RJ-in. Malah justru sebaliknya, kalau misalnya basisnya itu adalah kealpaan atau kelalaian, apapun akibatnya, baik itu dia mengakibatkan kecacat, mati, akan lebih mungkin menggunakan RJ daripada kalau sumbernya itu adalah didasarkan pada kesengajaan. Jadi kalau saya melihatnya dari karakter perbuatannya itu kesengajaan atau dolus apa kulpa gitu. Kalau dia kulpa, menurut pribadi saya sangat mungkin untuk dilakukan RJ. Tapi kalau sudah dia sengaja, walaupun akibatnya kecil, sengaja itu sudah tercela moralnya sudah lebih besar daripada suatu kulpa. Jadi untuk extraordinary crime itu pendapat saya itu tidak cocok untuk di-RJ-kan karena ada unsur kesengajaan, ada perencanaan, sifatnya masif, dan itu seterusnya. Kemudian terkait tadi RJ untuk anak di bawah umur. RJ untuk anak di bawah umur, ini menarik lagi nih. Kalau tadi basisnya adalah dolus culpa, ini sudah di bawah umur gitu ya. Kalau di bawah umur, dolus pula itu kan. Mungkin gini, kalau dia untuk anak di bawah umur, kita mungkin pendekatannya itu adalah mungkin perlu ahli juga bidang psikologis dan kesehatan anak. Apakah di usia tersebut dia secara psikologis sudah mampu atau dia menyadari perbuatan dia itu salah atau enggak. Jadi perlu diskusi lagi yang lebih mendalam terkait itu dari perspektif multidisiplin yang lain supaya nggak jadi bias kitanya gitu ya. Apalagi? Udah. Oke, terima kasih.
Okay. Thank you, Dr. Hamonangan Albariansyah. The next question is from Farid about how do we solve the genocide. The first session we pierced Dr. Mahbub to answer first about the question from Farid, how do we solve the genocide? Dr.
Thank you very much,
yeah.
Doctor. Thank you very much. Our students raised the questions from the audience. Yes, it's a political question. It's not the legal questions. How to stop the genocide? It's not a legal matter. It's a political problem. So political problems. Yes, we have legal matters. We have the legal instruments, such as genocide conventions. It's 1948. It was adopted. It was one of the first UN human rights treaties to protect the humanities. 1948 in 9 December until now 2024. Does it mean that we stop the genocide? International legal instruments we have. Look, in Southeast Asia, 1975 to 1979, what happened in the Cambodia? 1971, during the Pakistan and Bangladesh war, what happened? We have Rwanda. We don't need to go far away, just I'm talking about the South and Southeast Asia. And recently in 2017-16, it needed political decisions. If perpetrators go unpunished, then it will be difficult to stop these problems. What happened in the cases of Cambodia, what I discussed with you in here, it takes 30 to 40 years. And now it is in primary stage of the prosecutions in International Court of Justice. And Myanmar situation is very much fragile. We don't know what will be happen after 2-3 years. Is it one country or 2-3 countries? Still, we are not sure. And role of the international actors is also very much complicated. So when there is one genocide conducted inside of the countries, it is, yes, definitely it's a problem of inside of the countries, particular countries. But other international actors also involving in here. We have international mechanisms. We have international law. The reality is international law could not stop the Rwanda genocide, could not stop the Bangladesh genocide, could not stop the Cambodia genocide and Rohingya genocide. If I'm going back a little bit, theoretical discussion, restorative justice, I don't think so restorative justice is really working in here, especially genocide survivors and who lost their family members in the genocide. I had to conduct some interview in 2017, February, after first round of the genocide. I understood and tried to, I got a lot of witness what happened in Myanmar. So it is very difficult actually to introduce this these approaches, especially the cases of the genocide. Yes, other criminal, because international criminal law ideas has been changed. And restorative justice, yes, it is meaningful. I am not undermining as a students of human rights, I am not making debate, but perpetrators should not be unpunished. If it is the cases of the crime against humanity, war crime, if we can establish some examples, then these problems might be reduced, but no one can give you guarantee that there is no genocide will be conducted again. It's a political matters, need to resolve the politically, and genocide not raises in one day fine morning. Even the cases of the Rohingya, many times international level, in the UN level discussions, and UN also asking to protect these people. But our international systems and regional systems not properly address these matters. From the ASEAN context, if you look, what ASEAN had done for them. After the military coup, there is Jakarta consensus, but it is not working. After after nearly 4 years, and genocide conducted 7 years before. There is no visible initiatives, and really it is not work out for them. And what actually I am discussing in my papers, yes, again, they are facing the same trouble, but actually UN human rights chiefs also reminding us situation might be repeated in 2017. It means that existing systems is not working for them. Thank you very much.
Thank you, Dr. Mahbubul, for your answer. The next one is especially for Professor Andre Klip from the Zoom chat. The question is, in the case of corruption or bribing state officials by foreign corporation, what jurisdiction principles should apply? And to what extent does international law, in this case is UNTOC and the protocols, also the UNCAC, or latest development in the International Criminal Law or ICC, the universal jurisdiction, influence the understanding and implementation of traditional jurisdiction in Indonesia as well as in the Netherlands? From Pak Tristan Pascal from Unpar, Indonesia. So to Prof. Andre Klip, the time is yours.
Thank you so much, Ms. Almira, and thank you to Tristan for the question. I think that the starting point is always that criminal jurisdiction is based on national law. So international law has an impact, but the basis is always that there must be a jurisdictional rule under national law. So for Indonesian criminal law to apply, you will find the rules in Articles 4 to 9 of your new penal code. If those rules give those rules apply to the conduct in combination with the special part, all the other provisions in the penal code, there is jurisdiction. International law may do two things. International law may limit national jurisdiction, and international law may justify national jurisdiction. But international law as such does not create it. International law may also impose an obligation to create jurisdiction, but that is on the basis of a treaty. And on that, concretely to corruption cases and foreign companies. If foreign companies bribe corrupt Indonesian officials, Indonesian criminal law is simply applicable because the offense relates to things that occur in your country, and the new jurisdictional principles are very clear. It is a territorial component. It happens in Indonesia, so there is jurisdiction. And the other thing is, if the conduct, if the perpetrator is outside, the consequences are felt in Indonesia. So a clear jurisdictional basis. What I do not know, but you will be able to say immediately, whether there is under Indonesian law individual criminal responsibility only, or if you can also prosecute corporations. If the answer on the basis of Indonesian law is yes, we can prosecute corporations, then you can also do that when the corporation is out of the country. I'm not saying that it is subsequently easy, but the first step is always, do you have jurisdiction? The second step is, can you actually act upon it? Can you collect the evidence? Can you make the arrest? Or can you ask for extradition? I hope that answers the question. Madam Chair, if you allow me, I would also like to say a few words on the genocide question, because that is quite an issue. Can I say a few words on that?
Yeah, Prof. Please.
Yeah. Thank you so much. And I fully agree with the previous speaker, my colleague Mabubul Haq, that it's all about whether the politicians want to bring an end to genocides, war crimes, and so on. What we see in when it comes to the criminal prosecutions, there are two main factors. One is the will, and other is the power. You may have the will, but if you don't have the power, it's not going to result in any prosecution. And if you have the power, but you don't want to, nothing is going to happen. One of the first conditions is also that you create your legal possibilities to prosecute. And on that I see, for instance, that Indonesia is not a party to the Genocide Convention. I don't know why. Indonesia is not a party to the International Criminal Court. That means that Indonesia has not created the possibility, the legal possibilities to join. I personally think it's sad. But on the specific situation of Gaza, Israel, that is currently, of course, on the international plane, hugely debated. I think here we are in the moment that the legitimacy of the International Criminal Court is now tested at its utmost. Because the International Criminal Court in the first 20 years of its existence has been largely supported by Western states. By EU states, by Australia, by Canada, of course not by the United States, not by Russia, not by China, not by India, not by other countries. It was a Western support. But here, with the prosecutions upcoming to Israeli officials, the West is now challenged for the first time to support the ICC when it deals with an ally. Thus far, the prosecutions before the ICC were easy to take for the biggest supporters of the ICC. It related to Afghanistan, it related to Congo, it related to African states, and it related to Russia, with the European states have no warm ties anyway. But now, it's about Israel. And this is something that you see with international crimes all the time. It's always easy to go after crimes committed by others, especially by states that you don't like at all. But now, can you also do this? Are you willing to prosecute crimes committed by your allies or even crimes committed by your own nationals? Here, there are very few states that have done so in the past. Very few examples of prosecution of your own nationals. I say that to the person who, the young man raising the question from the audience, and I realize that you may be disillusioned, you may be disappointed about the power, but this is a fact of life, and my colleague, the previous speaker, already highlighted that. It is about political will. But before the political will to act, you must create the legal circumstances that you can act. And that is, I think, what I would call upon you. Please create the legal possibilities, and then we may see at a certain moment the political will to go after the crimes that are now committed in Gaza, now committed in Lebanon and elsewhere in the world. Thank you so much.
Thank you so much, Prof. Andre Klip, for your answer. So the last question is for all the speakers, and I guess the speakers, after answering the question, may have tell us the closing statement, including the answer. The question is, given the rapid advancements in technology and the increasing complexity of transnational crimes, what do you believe is the most pressing challenge for modern criminal law systems? How can countries, especially those with developing legal frameworks, adapt their laws and enforcement mechanisms to effectively address these emerging issues while balancing human rights considerations? We begin from Professor Dr. Inyoman Nurjaya. The time is yours, Prof. Oke. Pesatnya kemajuan teknologi, meningkatnya kejahatan transnasional, bagaimana sistem hukum pidana modern, terus bagaimana kita mengatasi masalah yang muncul sambil menyeimbangkan human rights. Prof.
Hello, Chair. As you know that society is dynamic. Dynamic as dynamic of the development of technology and science. And criminality follows the dynamic of society. That's why the criminal law should also be followed as the humans. Law as human. It means that law should be protect the rights of the people, especially in case the people who committed a crime. In legal state, the rights of the people protected by the state, by the law. That is why the principles should be getting by the state on how to develop a criminal law reflected the protection of human rights. The law should be humans, not humans for the law. If the law for humans, then the ways taken to make humans harmonious purpose in society, it need to be established a part of human efforts. Restorative justice is essentially as alternative resolution attempt to obtain win-win solution agreement in a certain criminal case settlement beyond the system. In order to obtain the fairness solution for the best interest for the victims and offender. Thank you.
Thank you, Prof. Nyoman. Please give applause to Professor Dr. Inyoman Nurjaya. The next one for Dr. Hamanangan, the same question. The time is yours.
Terima kasih. Jadi yang menjadi inti dasar dari permasalahan yang diutarakan oleh moderator itu adalah kita itu bermasalah pada 3 hal poin dari penegakan hukum sebenarnya. Satu, yang kita harus fixkan dulu itu seperti apa sih legal framework yang mau kita imajinasikan itu seperti apa dulu. Kita mau kemana dulu, kita buat legal frameworknya itu mau kemana dulu. Setelah regulasinya sudah dibuat, sudah dirancang sedemikian rupa, kemudian peningkatan kualitas aparatnya. Bagaimana mungkin sebuah regulasi yang bagus tapi yang menegakkan hukumnya juga nggak bagus gitu. Itu harus sinkron dua-duanya. Yang terakhir adalah kita kultur masyarakatnya gitu. Regulasinya udah bagus, terus lagi aparatnya udah bagus, cuman kalau kultur kita sendiri juga masih gitu-gitu aja, ya sebegitu-gitunya juga gitu. Jadi 3 itulah harus kita selesaikan. Minimal apa yang sudah terkait dengan tindak pidana bidang elektronik tadi ya, misalnya terkait dengan tindak pidana bidang elektronik, salah satunya itu salah satu yang disampaikan oleh narasumber OJK adalah minimal untuk mencegah terjadinya tindak pidana minimal tidak mengupdate status di media sosialnya itu setiap hari. Itu salah satu upaya pencegahannya itu adalah karena dengan teknologi AI itu satu foto itu bisa memperoleh informasi yang lebih banyak tentang profiling siapa diri kita gitu. Itu salah satu mungkin yang kita bisa lakukan adalah itu tadi, apalagi kita pengguna media sosial karena itu terkait dengan perlindungan data privasi, perlindungan data pribadi dan juga Undang-Undang ITE. Saya rasa itu yang bisa saya sampaikan Ibu Narrator. Sekian, terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Give applause for Dr. Hamanangan Albariansyah. Thank you. The next is Dr. Mahbubul Haq. The same question.
Yes, as students of human rights, I would like to say that there is a technological development, and technological development we cannot ignore it. So how to ensure the justice? There are some issues such as cybercrime. It was not addressed 20 years before, and there are many crimes are coming, and then it is time to address it. How will you address it? And at the same time, need to ensure that who is accused person has right to defend it, and his rights should not be violated. And sometimes, we are tagged that, oh, this is like this, and it should not be like this way. So in particular cases, we will need to understand, and yes, it is not time, not the time that yes, we had done this justice and these issues properly addressed and investigated, and at the same time we need to understand where it was conducted. It is conducted from the Western countries or from Asian countries. So what about the perspectives? Is there any motivated or not? So in this way, need to redress or rethink. Again, I'm going back to the restorative justice and the criminal justice emerging issues. If I've been saying that it's emerging issues in the criminal justice. So, so not looking from the traditional way. Traditional way is actually we have some legal framework. And this legal framework is not like the Bible, we cannot change it. We can change it, and we need to understand the thing and need the modern ideas and how it was working and not why it's not working. And then I would like to say one size formula is not for all. So why we need to think it innovation way and how to address these new problems and not only looking through the existing legal framework. And again, I would like to repeat, need to ensure individuals' responsibility and rights should be ensured. Thank you very much for for giving me this space to answering the questions.
Thank you, Dr. Mahbub. Please give applause to Dr. Mahbub. The next one is for Professor Andre Klip. The same question for you, Prof. The time is yours.
Yeah, thank you so much, Madam Chair. The challenge has always been to the development of law to keep pace with the technical developments elsewhere. The law is always responsive. It cannot predict certain technical developments. And in practice, we always need to see first what are the consequences, the negative consequences that affect the life of the citizens. So in that context, also the IT developments that we have now, as such, are not new if you compare it to developments of 100 years ago or 200 years ago. The law always lags behind. So that, as such, is not new. At the same time, having said that, there are a couple of things that are different, and they relate predominantly to the fact that it is now far more easier to commit a crime when you are far away from the country or where the consequences are felt. It is possible to commit crimes without even the victims knowing who did commit the crime, especially when you make use of IT or AI devices. And here is a huge challenge. Here's a challenge that states will often not be able to combat those type of crimes all by their own. So international cooperation is needed, and further specialization and expertise is needed to understand what is going on. And that here I think there are challenges that are on the table for all states in the world, because the old days that we only had physical crimes by the use of human force are gone. Those crimes still exist, but we have another type of crimes that may have a huge impact on our societies. Having said that, I already tried to sketch in my presentation that with your new jurisdictional rules, you have set in Indonesia the first step to do that. But I would also say, please pay attention, because the developments go fast, and don't wait too long to amend the penal code again in order to create the possibilities, and look at the accompanying provisions in the Code of Criminal Procedure. The penal code is not a standalone thing. If you don't have investigatory powers to go after offenses that affect you as a country, because you cannot cooperate with states elsewhere to investigate and to collect evidence, it's no use to have the penal code only. Having said that, I thank you very much once again for inviting me to your university, and I congratulate you to your birthday and wish you all the best. Thank you so much.
Thank you so much, Prof. Andre Klip, for your answer and your closing statements. As we bring the enriching seminar to a close, I would like to express my sincere gratitude to our distinguished speakers for their insightful presentations. And today we had the privilege of exploring critical developments in criminal law from diverse global perspectives. From Professor Tim Lindsay, he highlighted how criminal justice reform is instrumental in achieving Sustainable Development Goal 16, emphasizing the need for strong legal institutions to foster peace and justice. From Professor Inyoman Nurjaya, he provided a detailed analysis of restorative justice within Indonesia's criminal justice system, showing how restorative approach can effectively address both traditional and modern legal challenges. From Dr. Hamadangan Albariansyah, he expanded on this by comparing workplace safety violations across ASEAN countries, demonstrating the importance of legal frameworks in ensuring accountability. And from Dr. Mahbubul Haq, he light on the Rohingya crisis, illustrating the ongoing struggle for justice and the critical role international law plays in responding to such human rights violations. Lastly, from Professor Andre Klip, offered an insightful comparative study of criminal jurisdictions in Indonesia and the Netherlands, highlighting the historical and legal nuances that differentiate these systems. In conclusion, today's seminar has provided us with a rich tapestry of insights into global trends in criminal law, each speaker offering valuable perspectives from the regions, and these discussions have demonstrated the importance of international cooperation and comparative analysis in addressing today's legal challenges, inspiring us all to strive toward more just and effective legal systems. Thank you for being a part of today's seminar on exploring global trends in criminal law, comparative perspective on emerging issues. It has been a remarkable day filled with insightful discussion and valuable learning experience. I would like to express my heartfelt gratitude to all those who made this event possible. A special thank for our Dean, Professor Dr. Joni Emirzon, to our Vice Dean, the head of the Criminal Law Department, and our senior, our secretary, for your unwavering support and guidance. I also want to acknowledge all the lecturers from the Criminal Law Department for the dedication and the contributions, and my sincere appreciation goes to the organizing committee, including our colleagues from ALSA, LC UNSRI, for your hard work and commitment in bringing this seminar to fruition. To our esteemed speaker, Professor Tim Lindsay, Professor Dr. Inyoman Nurjaya, Dr. Hamonangan Albariansyah, Dr. Muhammad Mahbubul Haq, and Professor Andre Klip, thank you for sharing your expertise and insights with us today. Your contribution have enriched our understanding of the complexities of criminal law in today's world. I also want to extend my gratitude to all the participants who joined us, both in person and virtually. Your engagement and your thoughtful questions have made our discussion more vibrant and impactful. To our seniors and fellow colleagues, thank you for your continued support and mentorship. As we conclude, I apologize for any shortcomings on my part during the seminar. It has been an honor to serve as your moderator, and I appreciate your understanding. I encourage everyone to take the insight gained today and continue the conversations in your respective fields. Please remember to fill out the feedback forms on the registration space outside. So, I think that's all for me. I am Almira, Novia, Zulaika has left the moderator. Thank you so much. Wassalamualaikum warahmatullahi wabarakatuh. I'm sorry for Dr. Mahbubul and Professor Andre Klip. I hope you still online with us because we have to share the certificate by online with Professor Dr. Joni Emirzon, also with Professor Dr. Inyoman and Dr. Muhammad Angan. Thank you.
We continue our event by holding a group photo session and symbolic certificate presentation to Professor Inyoman Nurjaya, Dr. Hamonangan, Professor Andre Klip, and Dr. Mahbubul Haq.
Bilang
We're gonna take it. We're going to siapa Profesor siapa? Andre Klip sama Mabubul. And also to Professor Andre Klip and Dr. Mabubul Haq, we're gonna taking a picture together here.
To Professor Andre Klip and Dr. Mahbubul Haq, we have already finished the photo session. Thank you so much. And the next agenda is certificate presentation to Professor Andre Klip and Dr. Mahbubul Haq. And also we are going to take the picture in 3, 2, 1. And okay. Thank you to Professor Andre Klip and Dr. Mahbubul Haq.
The last session concludes all of our agenda for today.
We would like to say our biggest gratitude to all the honorable guests and participants, speakers, and our moderator.
Our biggest hope is that all of you can get all the valuable learnings through this seminar. Lastly, I am Bonita Mayunita Arwan and my partner,
Muhammad Adriano Octavianza, stands our farewell and we'll see you in another opportunities. Untuk teman-teman peserta, Untuk teman-teman peserta yang tadi bertanya, boleh mengambil cindera matanya ke depan. Dan juga untuk daftar hadir boleh diisi di depan meja registrasi. Terima kasih.